The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The webinar will begin shortly. Please remain on the line. The broadcast is now starting. All attendees are in listen-only mode.
Good morning. It is 9 a.m. on Thursday, May 20th, 2021. And this is a virtual hearing for the purpose of conducting a protest hearing on the recall of Councilmember John Voles. My name is Karen Goldman, and I have been appointed by the Westminster City Council to serve as the administrative hearing officer for this recall protest. I have some preliminary remarks I'd like to make before we get started. And the first thing I would like to do this morning is to identify the actions that have taken place prior to today's hearing. Recall petitions were approved as to form by the Westminster City Clerk on September 1st, 2020. Recall petitions were filed by the Recall Committee, Westminster for Responsible Government, on October 30th, 2020. The minimum number of signatures for Councilmember Voles that were required to be submitted based on the formula in the Westminster City Charter was 6,098. The number of signatures that petitioners indicated they turned in for Councilmember Voles was 6,763. And upon review and verification, the city clerk originally certified 4,706 signatures, which was below the threshold required to move forward with a recall. And on November 13th, 2020, an initial determination of insufficiency was made. In anticipation for the possibility of a protest hearing and the need for a hearing officer, the Westminster City Council appointed myself, Karen Goldman, as the hearing officer at their meeting on October 12th, 2020. Protests to the initial determination of sufficiency were filed by the petitioners, then withdrawn and refiled. And then on December 10, 2020, the city clerk, after further review, issued an amended determination of insufficiency on the recall petition for Councilmember Voles. This amended determination was then reviewed by the courts. And on April 16, 2021, the court issued an order that the city clerk review the signatures on recall petition sections that had been previously disqualified. That review was completed on April 28, 2021, and at which point the city clerk determined that 6,107 valid signatures had been submitted. The recall petition was thus sufficient, and a recall election for Councilmember Voles could move forward. On May 6, 2021, a protest to the city clerk's determination was filed by Christopher Stimson, alleging the following 3 points. Number 1, petition section 33 should be disqualified in its entirety due to improper petition sections and line numbers. Item 2, individual signatures on several petition sections should be disqualified for reasons including and not limited to improper dates, illegibility, or an inability to identify the signer by name, and that the petition address was not the same as the registration address. And 3, that the conduct by the petition committee and signature collectors substantially misled persons who signed the petition. And a protest hearing was scheduled for today, Thursday, May 20th, 2021. So I am going to take administrative notice of the recall petitions, the filed protest, the city clerk's determination of sufficiency, the relevant portions of the Westminster City Charter and City Code, the voter registration list used to verify the signatures, the witness list, and the evidence submitted in accordance with the pre-established procedures for this hearing. The evidence will be marked and considered a part of the final record. So, having said that, here's how we are going to do this today. The protester will have the opportunity to present information and evidence that has been provided by the designated deadline. If Councilmember Voles is present, he will have the opportunity to respond, as will the petitioners, and I, as hearing officer, will also be able to respond to the testimony and the evidence that is presented. All witnesses will be sworn, and their testimony will be under oath. I want to make it very clear that when it comes time to deal with item 2 and we review the signatures, we will be reviewing only those signatures on the petition sections that are part of Mr. Stimson's protest. These signatures are the only matters under consideration today, and no additional signatures can be questioned or considered in this hearing. Now, I understand that there are legal representatives for both the protester and the petitioners, and so I would ask that each identify himself and state and spell your name, and then let me know who you're representing. So I'm going to begin with the legal representative for the protester. And so if you are muted, please unmute.
Good morning, Your Honor. It is a pleasure to be with you. My name is Jerome D. Herrera. My last name is spelled D-E-Herrera. I'm a licensed attorney here in Colorado under bar registration number 35893, and I represent Mr. Christopher Stimson, an eligible elector here in the city of Westminster who brought the protest.
Thank you.
Good morning. My name is Scott Gessler. I represent the recall committee.
Okay, thank you. So while this proceeding is open to the public for those who are watching, other than those people whose names have been submitted as witnesses, they will not be permitted to testify, to chat, to otherwise comment, and no member of the public is permitted to question any of the witnesses. I just want to say, and I'm sure you all know this, recalls are contentious, they're very personal, they are contentious and personal not only to the people subject to recall, those seeking it, but also to members of the community. So again, I'm going to ask that unless you are speaking, you stay muted. You may also turn off your video if you choose. I'm going to leave that up to you. I want to make it clear that I have discretion to determine what testimony is going to be related to the protest, and anything that runs wide of the items listed in the protest will not be permitted. It is my intention that we start and finish this protest hearing today. I'm going to ask that people not repeat themselves. If something has already been said, it need not to be said again. And I think before we get started with Mr. D. Herrera, I'm going to ask if there's any questions about anything that I've identified at this point.
Ms. Goldman, this is Scott Gessler. I'll turn on my camera. I just want to confirm. So my understanding is that you are not going to consider the additional signatures that we seek to rehabilitate as the recall committee. Is that correct?
The only signatures that you can rehabilitate or discuss will be the ones that were listed on the previously disqualified petitions. And I believe you have a number of those signatures.
Correct.
As for the others, no, we're dealing with the protest that was filed, and they do not include anything other than the previously disqualified petitions.
So just so I understand, and I apologize, I will represent to you that the signatures we submitted only came from the Volts protest and were previously disqualified. Does that mean you'll be considering them with that representation?
I am not going to, so maybe if I do this, it'll make it easy for you. The signatures that we will be dealing with today are the signatures on the petitions that were part of the protest filed by Mr. Stimson. So they would be the signatures listed on petition sections 25, 32, 33, 34, 36, 37, 43, 44, 45, 49, 51, 53, 60, 61, 68, 69, 78, and I believe you got a copy of those.
I did.
I noticed in your motion to intervene, which quite frankly, Mr. Gessler, I was always going to be, you were always going to be eligible to participate in this
I
hearing.
understand I understand it's sometimes a belt and suspenders approach.
That's fine. I noticed that you listed a number of signatures on petition sections that were not included in the list. Those will not be considered today.
Okay. Thank you.
Okay. Anything further? Thank you, Mr. Gessler. Mr. D. Herrera, you may begin.
Thank you, Your Honor. And if I might begin with a few housekeeping matters. With regard to the administrative record, I apologize if I missed this, but will Your Honor also take judicial notice or administrative notice of the statute that we are under today, which is section 314503, subsection 3B? Is that also in the administrative record?
Yeah, I will do that as well, yes.
Thank you, Your Honor. While we're on that topic, to the extent that Mr. Gessler and the recall petition committee seeks to rehabilitate any of the signatures that we are protesting, I'd like to just put a running objection so that I don't have to do it each time. But under that section, as we just mentioned, the petition committee does not have a right to rehabilitate under subsection 3B. Whatever right to rehabilitate or cure an invalid signature comes in a different subsection, which is not the subject of today's matter. So I would just like to put on the record that I have a running objection to their ability to attempt to cure or rehabilitate. Today's protest hearing, in our eyes, is being held under subsection 3B, which does not give them that right. Their right to cure, to the extent they have one, is under a different subsection, which is outside the scope of the City Council resolution governing our hearing today.
That is duly noted. I will say that to the extent that the petition committee has the ability to, let's see, I'm trying to think of a word that is neutral, comment on the arguments that you make, I will be allowing that.
Yes, I agree with that, Your Honor. We're not trying to say that they don't have a voice and they can't test our protest. It's just a different stage when you try to cure something that is invalid or does not meet the statutory or constitutional requirements.
Well, since they are going to be dealing only with the signatures that you are seeking to disqualify, I don't see that they are seeking to cure or rehabilitate. So again, what your comment is duly noted.
Thank you, Your Honor.
Okay.
That was the first and second housekeeping. Another item of housekeeping, we did raise 3 grounds in our affidavit, in my client's affidavit. We will not be arguing for the 3rd ground, which was improper conduct. So that's an argument we're not going to raise today.
And thank you. And while we're on the just a couple things. You'll see me pause, and that's because I'm writing. You may see me move around. That's because I have a whole lot of material spread out on this desk along with me. So please just indulge me. When we get to item number 2, and let me just say this now, and when we go through a line by line, the way I want to do it, to me, which is the most efficient, is to allow the protester to make his remarks, make your remarks, and then immediately allow Mr. Voles, if he's here, or the petition committee to comment so that it's easier for me to keep track of it. It will be a lot easier for me when I prepare my findings. So rather than make an entire presentation and then have to go back and figure out what we're talking about, we're just going to do it line by line. And again, because there are a significant number of signatures in question, I am going to ask that we be concise, to the point, and not repetitive. Okay?
Yes, Your Honor, that makes sense to me. I think I understand that. And you may also be pleased. There are some on second and third consideration that we may drop, that we won't argue today, and I'll point those out so that we don't use your honor's resources when it's not needed. So I'll point that out.
Okay, that's fine. Thank you. Are you ready to proceed then?
Yes, and would you like me to share screen? I'm assuming we're not going to bring any live testimony today. We're just bringing the evidence and argument with regard to the exhibits that we submitted, and we'd like to start with page 1, which is one of those objections. Would you like me to share screen, or if you're looking at it and I'm looking at it, I don't need to share it. I can just walk you through, and then we would obviously pause if you have questions or if anyone has comments, as you said.
Let's see, Mr. Gessler, do you have access to the same documents?
I believe so, Your Honor. If I don't, I'll let you know.
Okay, all right.
I think it may be easiest though if we do a screen share.
As long as I'm not the one that has to do it, I'm fine with that.
Okay, it looks like I got a message, a pop-up that says show my screen. So give me a second and I'll try to.
Whatever time you need.
Okay, thank you.
And just so you know, I have paper copies of the materials that have been provided by both the protesters and the petitioners. And I have them in paper because I'm old-fashioned. So a lot
I
easier.
wonder if staff could do the screen share. I'm having, and then we can walk them down.
Since we all seem to have that information, you know, it may not be necessary.
Okay, that would be fine too. And I'll just be very clear as to what page I'm on.
Okay.
Let's see. Okay, so thank you, Your Honor. We would begin with page 1 of our exhibit, and this page. And for ease of presentation, we put at the top, and sometimes it ended up on the bottom of the page, but we put the objection number as well as the section, line, and then the basis of the argument. And so here this is what we've labeled as objection number 1. This is on section 25, line 1. We believe that this signature should be ruled invalid because of the date. The date to me appears to be December 12th, 2020, which would be after the affidavit signature, which would render this signature invalid.
Mr. Gessler, comment?
Certainly, Your Honor. I have 2 comments. I mean, we think that that's properly interpreted as a 10 instead of a 12. The clerk also interpreted it that way. And in fact, we'd say it's logically impossible for it to be dated the 12th, December 12th, because these petitions were actually received by the clerk and reviewed by the clerk well in advance of December 12th. So it would be impossible for them to have signed it on December 12th, yet somehow have submitted the signature well in advance of December 12th. So October 12th is the proper interpretation. That's the clerk's. It's the only one that possibly makes sense. And certainly under the substantial compliance test, it should be qualified as a signature.
All right, I have no comments.
Your Honor, we would drop our objection or protest number 2, which was section 32, petition line 9. We would drop that protest.
Section, okay. Hold on, again, I need to write these things down.
Take your time.
I will, thank you. All right. Continue.
Okay. I am on page 2 of our exhibits, which relates to what we labeled as objection number 3. This is on section 33, line 7. Our objection here is that this signature should be ruled invalid because the person's voter registration cannot be confirmed. This person lives at 9791 Irving Court, and that person cannot be found in the voter registration records.
So when you say can't be confirmed, what you are meaning is that they are not in the voter registration records?
Yes, this information does not match the voter information records. There is a Michelle Abeda at a different address, but this information does not match the voter records.
Hey, sorry to interrupt. This is Matt with the city IT support. Did you want to continue sharing your screen, or did you want me to take that off?
Please take that off. Is my screen being shared?
Yeah, I'll turn it off.
Okay, there you go. So what, Mr. Gessler, do you have a response to this? I have a question, but I want to give you an opportunity to respond.
Yeah, I do, Your Honor. How would you prefer to be addressed in this hearing?
Ms. Goldman, I'm
All right, Ms. Goldman.
However, if I know that for people who are used to hearings like this, it's automatic, and I won't dissuade you. I'm going to assume it is an honor to be called Your Honor. So, however you'd like.
Okay, well, I'll work with Ms. Goldman, and you have my apologies if I currently call you Your Honor.
You would not be the first one to do that.
Okay, so we have 2 responses. The first is, and I apologize with the with my computer screen and all, I'm having some difficulty navigating documents, but I believe we have an affidavit from Ms. Abeda explaining the fact that she had moved, and so I'm trying to find that in our packet of information that we provided to you.
I do have a copy of it myself. I don't know, Mr. D. Herrera, if you have that.
Yes, Your Honor. I do have Mr. Gessler's documents, and this goes to the point, and maybe I can make the point more salient as to our running objection. It may be possible that this type of deficiency could be cured under the other subsections of the statute. In the protest hearing, there is no right to cure or rehabilitate a deficient signature. The right to cure comes in subsection 3C, basically, which says, and stop me if I'm saying something you already know, but it says that the petition committee, the recall committee, can withdraw their petition. They can try to cure, supply missing information, and then they could resubmit that. The problem that the petition committee will run into is that subsection is also very clear that you only get one chance to do that. And this committee took that chance and did that in November. So they withdrew their petition. They made cures or attempted cures. They resubmitted that as an original submission, and then the clerk ruled on it. The court took the case, and now here we are again. So the committee just doesn't have a right to cure anymore under that subsection. Now, for today's hearing, today is just about the protest, which relates to the point in time in which the person signed the form, signed the petition. And today's question is, was that a valid signature that day? Today, the question is not whether it can be cured.
If I may respond, Ms. Goldman, I think that's a misconstruction of the statutory approach, and frankly, a hyper-technical reading that essentially extinguishes rights. First of all, there was no opportunity. First of all, a cure to understand what a cure is, it means a signature that has been rejected and needs to be cured. This signature has not been rejected. This is not a cure process. We are defending the signature as part of the evidence in this hearing, which we have every right to do. It was impossible for us to cure this signature in the past because it was not rejected. These are signatures that were properly accepted by the clerk. We were told that they were accepted. They were accepted as part of the record. So there was no basis to cure something that's already been accepted. Furthermore, Your Honor, you'll see substantial, and I can provide citations maybe at the break, I'll pull them up, of where the Supreme Court has specifically recognized it in these protest hearings, that the committees, whether it's a candidate committee or a ballot an issue committee, or a recall committee in this instance, can provide additional information at a hearing that will allow the court to consider, or in this case, an administrative hearing, which does not require formal evidence, according to the rules of evidence, but will allow you to consider this information. So there was no cure process because these weren't, there was not a problem with them. We are not rehabilitating signatures right now. The burden of the proof, the burden of both production and persuasion is upon the protesters to try and strike these signatures. And we're providing evidence to show that they should not be stricken. And they are within the confines of what you have ruled as the signatures that are under review and to accept evidence. It's sort of the other argument would essentially extinguish any ability to provide any additional evidence to defend a signature, which is wholly improper.
Thank you. Mr. Gessler, I noticed that on this and on other similar affidavits that you provided, people have indicated where they were registered and the fact that they had moved to another address. Do you have any information as to when they might have moved to that address?
So, Your Honor, in some instances, I think we may, but I would also like to back up with another argument. They are still registered voters in Westminster. There is no statutory requirement that their signature absolutely match the voter database. If you look at the Colorado statutory framework 1-1-104 subsection 35, which was cited by the protesters, it says a person has to be registered and eligible to vote in that jurisdiction, which every single person here is, especially because of the statutory framework in Colorado, where if someone lives within, for example, a jurisdiction and moves, they remain registered. Okay. What the statute does say, and if you want, I can cite it. In fact, I can even pull up the citation that I think was accurately reproduced by the protesters here. But it says, if any provision of this code requires the signing of any document by a registered elector, the person making the signature shall be deemed to be a registered elector if the person's name and address at the time of signing the document matches the name and address of the person on the registration document, the county clerk and recorder's office, and as it appears on the master elector list. So that certainly provides latitude. It allows the clerk or the reviewer to deem the person, but it is not exclusive, nor does it say it only has to be, the address has to match. In this instance, the person was and is properly registered in Westminster, and even if they've moved within Westminster, they remain eligible to vote in Westminster. So a move within Westminster, and this applies to multiple rejections, I believe this is why the clerk properly accepted these, they remain an eligible elector. And there is no doubt that striking this person would essentially disenfranchise them from being able to participate in the recall election, because there is no dispute, I believe, that they are registered in Westminster and they continue to live in Westminster, even if it's not the same address.
Your Honor, if I might reply,
Go ahead.
with all due respect, I think Mr. Gessler helps to make my point. What Mr. Gessler is advocating is that Your Honor needs additional information to confirm that Ms. Abeyta was a registered elector the day that she signed the petition. You need additional information to reach that because when we looked at the voter registration records, there's no Michelle Abeyta living in 9791 Irving Court registered. So on its face, you can't confirm that that's a registered elector. So this person would need to be her signature in order for the clerk, in order for Your Honor to confirm that she was registered that day, which is the requirement. You would need additional information. You would need an affidavit from Michelle Abeyta explaining that this is the same Michelle Abeyta who is found in the registration records at the address that's in the registration records. It's not that the address had to be the same, but it's on the form. In order for this signature to be valid as of the day that she signed, that we have to be able to confirm that she was registered, and we can't do that with this information. So as Mr. Gessler pointed out, you need additional information. You can only get the additional information once the petition committee withdraws it and then resubmits their petition with the additional information, which is not the opportunity that they have today.
Okay, I think I understand both positions regarding the term cure. So if we could move on.
Ms. Goldman, may I make just one final comment, and I will keep it brief. I think Mr. De Herrera misunderstands my arguments. I am saying you do not need additional information because she lives in Westminster. We have information that this person is registered in Westminster. We have information that she also lives in Westminster based on the voter registration database, which is available, and based upon the petition. That in and of itself is enough. My second argument, an independent argument, is you've also received an affidavit from her that you should and can properly consider that confirms that she is the person who registered. So in one instance, you do not need additional information, and just as the clerk did not need that additional information. In the other instance, I have given you information as well.
Thank you. Mr. De Herrera, what voter list did you use to make the determination that on this particular signature and others that are very similar? What list did you use?
We made a Cora request to the Adams County Clerk, and we asked for the current voter list, and we also asked for all of the each voters for all of our protests, those individuals identified in our protests. We asked for the prior actions in their voter record, which would have showed where they moved and things like that. And I believe the voter list was compiled by the clerk for the protest, so we didn't put it into the record, but we can certainly supplement the record so that you have exactly what we looked at. And for most of our protests, let me see if we did it on this one, we added the screenshot. So if you'll look on page 3, we have a screenshot that came from the file that we received from the clerk to show that there is a Michelle Abeyta registered on 7133 Winona Court, Westminster. Now, had the signature information matched that, we could confirm that this person who signed was registered that day. But our argument is on the face, you can't confirm that. You would need additional information to confirm that this is the same Michelle Abeyta. With all due respect to Mr. Gessler, there are more than one Michelle Abeytas. It could be the same, but the point is you need additional information to confirm that because the records don't match.
Ms. Goldman, may I suggest that you simply take judicial notice of the voter database rather than relying on these reproductions, and if you feel a need to check them, you can do that.
I have a question for the city clerk. Ms. Parker, first of all, I'm going to need to swear you in, and then you'll remain sworn in for the entire extent of the hearing. So if you'll raise your right hand, Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Sure.
I do.
Okay, thank you. And if you can state and spell your name.
My name is Michelle Parker, spelled MICHELLEPARKER.
And your position.
I am the Westminster City Clerk.
So could you, when you checked the signatures on the disqualified petitions, what voter registration list did you use?
I used the voter registration list that was obtained from the Adams County Clerk, as well, which was Westminster voters only, as well as the list provided from the Jefferson County Clerk of Westminster voters only. And then, of course, I was granted access. I requested and was granted access to the Secretary of State's database as well.
And the date of the two voter lists from the county clerks?
Going on memory, forgive me. When we first verified signatures, I believe that and I apologize if I forget which one I got on which date, but I believe I received the Adams County database on October 30th. The day that they turned in their petitions. They turned in their petitions middle of the day on a Friday. I received it later that day, I believe, Adams. And then the Jefferson County database was received the following Monday, which was November 2nd, I believe. And that can be confirmed in the original certification that was noted in the original certification.
And what list did you use to check the signatures on the sections that the court indicated you had to check?
It was the same lists.
Okay.
We did not obtain a supplemental list or a new list. It was the same.
Thank you.
Your Honor, can I also clarify? We also submitted a core request to Jefferson County and used the current list that they sent us. So it's both Adams and Jefferson. And you'll see in our exhibits that in the voter profile report, it shows the date that the list was run. Like this one on page 3, for example, was run on May 13th. And the name of the official at the clerk is Jace Richards, I believe.
Yeah, okay, all right. Any further comments on objection number 3?
I have none, Your Honor.
Okay, so continue, please, Mr. De Herrera.
Thank you. I am scrolling down to the top of page 4, and this would be objection number 4, section 33, page 14, line 3. Our objection here is that this signature should be ruled invalid because required information is missing. In particular, the signer did not include their address. It's also unclear, and we believe that they did not put the county, although an argument could be made that Jeff on the top line could be that. But in any event, the signature is invalid because they did not supply all the required information, which is their address.
Mr. Gessler, any comment?
Certainly. My comments are pretty clear. First of all, we do have an affidavit that has been submitted from Ms. Provost, affirming that she indeed was the person who signed this. And so you have that evidence in front of you. And second, the line itself says that she was from Westminster, contains her name, it contains her signature. And she was in fact found in the voter database as a eligible voter. And again, I point out that the statutory framework it explicitly does not require a perfectly matching address. It simply says if there's a matching address, then that person can be deemed registered for signature purposes for a document. And that's a very important distinction in the framework. So again, there is an affidavit before you. And then I would like to make one final comment. The case law and decisions are replete with instances where someone has signed a petition and omitted their county. If, and those are accepted, if there's only one address at that municipality or in that county that matches. I think certainly under any reasonable standard and absolutely under substantial compliance standard, the words JEFF period are acceptable for Jefferson County.
Your Honor, if I could just reply, we put our objection on the record to Mr. Gessler trying to cure this with additional information that is not part of the record or of the petition. I would also just point out, perhaps the county requirement is, you could say substantial justification applies there, but they're missing other information that's required by statute. And the Supreme Court and the Colorado Court of Appeals have been clear that even though the right to petition is a fundamental right, it does not allow the courts or an administrative body to overlook requirements that are missed. And this is one of those requirements. There's no address. And, you know, it also goes to the point, can you confirm that this is the person who's registered?
Ms. Parker. You identified this person as a resident of Westminster, correct? Or did you? I should not we.
I believe I did.
Okay. And with a missing address, how did you determine that the person was registered and eligible to sign?
With the affidavit that was provided by the recall committee.
The one that we have under consideration now?
I believe so.
So did you receive that affidavit prior to today's hearing?
I apologize. I misspoke. That is not correct.
Okay. So with a missing, let me speak in broader terms. If an address is missing, what do you do when you're checking signatures?
Right. On first pass, an entirely missing signature would be considered invalid because we simply would not be able to match a voter to a name.
And what do you mean by an entire missing signature?
I'm sorry, let me be clear. If we were reviewing the petition and one of the signature lines contained only a first and last name and the signature with absolutely no address information of any kind, there is no way to verify whether that person is registered or not. Therefore, we would have deemed it invalid, and the reason because it had an incomplete address, incomplete line, not enough information.
So is it then your statement that because Ms. Provost neglected to include residence information, that this was a signature that you had disqualified?
I apologize. I do not have my complete database in front of me at this time to look up what the final disposition of her signature line was.
Madam Hearing Officer, this is Assistant City Attorney Matthew Munch. If I could just have one moment with Ms. Parker.
Sure, absolutely.
Thank you.
I think I can help here for a moment. On a, I'm looking here at a petition section 33, which you'll want to talk about later, is being challenged for some irregularities in the numbering and things like that. And so on the appendix to the protest, it shows as that the petition line is line 3, but that the clerk shows it at line 60. So what I am looking at is a document that was provided as part of your revised determination of sufficiency and posted online and available to everybody. And it does show that on petition number 33, petition section 33, line 60, Colleen Provost is listed as a valid signature and with a statement, no address information in database of same name. So does that help with your recollection?
It does. Thank you.
Okay. And that is what you would do then, is that if you could find a name, even though there was no address, you would consider it to be valid?
Not necessarily. And I apologize. I don't have the entire set of disqualified petition sections in front of me, nor the database and our notations from the verification. But if no further information was provided to me, then no, I would not. If further information had been provided to me, which I suspect has been or had been at that time, then we considered it. Any line that remained totally incomplete without any kind of address provided at all would not have been deemed valid without further information.
And what would that further information look like?
When the petition committee withdrew and refiled originally in November during the preliminary cure period, they provided affidavits that had further information. They provided an argument that certain things should be considered under the substantial compliance argument, or standard rather. And then when I was ordered by an Adams County district judge to consider the disqualified petition sections and to consider them under substantial compliance, that is what we did.
And one more question relating to this. Hypothetically, had there been two persons with the same name and no address, what would you have done?
That would have been impossible to determine which of the two was the person in question, hypothetically.
Okay. Thank you. Thank you. Okay. Are we ready to move on to the next one?
Yes, Your Honor, if you are.
I am.
Okay. Let me scroll down. I am scrolling to exhibit page number 5, which relates to our objection number 6. And I think for the record, we've dropped objection number 5.
Okay. And may I interrupt, Ms. Goldman? I apologize. I had a few problems with my mic. I would like to ask the clerk just a few questions regarding that last signature.
All right. Go ahead.
Okay. So Clerk Parker, do you have the exhibits in front of you that are all part of this hearing?
Yes, I do.
Okay. So I'd like you to go, if you could pull up the affidavit for Ms. Provost that we had submitted. Do you see that?
I do.
Okay. Now, with that in front of you, I'm going to ask you, is that information that would satisfy additional, if you were concerned about a missing address, is that information that would satisfy that concern and enable you to accept the signature?
A sworn affidavit from the voter providing information that was previously missing. In all cases, we allowed as cured. We considered cured. That's correct.
Okay. Thank you very much. That's my only question.
Your Honor, we put our objection on the record again to Mr. Gessler's attempt to cure the deficient signature.
And we would argue yet again that this is not a cure, that this is defending a signature. The signatures at this point have not been rejected. The protesters have the burden of trying to reject a petition before a cure process even starts.
Okay. I think I understand the argument about cure. So we don't really need to rehash it over and over again. You can state it, but I get it. Okay.
Thank you.
You're looking at number 5, and I'm not sure if I have number 5 in front of me. What page are we looking at?
Number 5 was, should have been, I think, section 34, petition line 1.
34, what page of your?
Let me pull my affidavit.
34 line 1. For some reason I didn't get a copy of it. Go ahead, because I've got the original ones. I just don't have
Okay.
that.
Okay.
And Stephen Kretzel, I believe, correct?
Yeah, I believe that's right.
All right.
So we're dropping that protest.
Okay. Let me make a note of that.
Our next one is objection number 6, and this would be on page 5 of our exhibits. This is on.
All right. Invalid. Right. Invalid.
Yeah, we believe that the signature should be ruled invalid because of the date. We can't read the date. We can't use the date to confirm that this was signed in front of the circulator because the date basically is illegible.
Gessler?
Certainly. As far as being able to confirm that it was signed in front of someone, every single petition section has an affidavit attached to it by the circulator that attests that they witnessed every single person who signed it. So having a ambiguous date, which we are not conceding, but arguing that is not a item that shows that that it was not signed in front of a circulator, because in fact circulators have sworn to that. At most, it's a difficult to read date, but it's still readable and it looks as though it's the 9th. But even so, one can use contextual clues or context to see that, one, it was certainly signed before the affidavits were turned in, because it appeared on the affidavit. It had to have been signed after the affidavits were printed, and it was signed before the signatures before it, and likely, before the signatures after it, and after the signatures before it. So that certainly meets any substantial compliance test. And I'm assuming that the person who actually reviewed that from the clerk's office was in fact able to read the date and recognize that. And every other indicia within that signature, the name, the address, the signature, all match the voter registration record, showing that it is a live human voter who signed it.
Your Honor, I would just reply that I think the document speaks for itself. There is something written there. What date that is, I can't tell. If I've looked at a lot of numbers and handwriting, and that does not look like a number to me, and unfortunately for this person. So that's all right. So we'll stand on that. The document speaks for itself.
All right. Okay.
Scrolling down to the bottom of page 5, top of page 6, this would be objection number 8. For the record, we are dropping objection number 7.
So you're dropping number 7, and number 7 is which one? Because again,
I believe Ryan Wolford. Should be section 34, petition line 33.
that information helps me because again, I don't have it in the written copy that I
Sure.
have. I do have access to the electronic version, so I'm not too worried about this. Okay.
Okay,
All right.
great.
Are you going to proceed to objection 8?
Yes, we'll proceed to objection number 8 if the court is ready.
Okay, I'm ready.
So this is objection number 8, section 34, line 38. This is like one we discussed before. We would believe that this signature should be ruled invalid because the voter registration of the person can't be confirmed. The address that the person put on the petition does not match the voting records. Therefore, additional information is needed to confirm this person's eligibility as a voter to sign the petition. Because that additional information is needed on its face, this signature should be ruled invalid.
Before you go, Mr. Gessler, Mr. Herrera, do you have information as to what the signature or the address is supposed to be? Because I don't see any.
Yes, if you look at the top of page, if you look at our page 6, there's the voter record for Mr. Vargas, showing that the Mr. Vargas, the Ivan Vargas, who is registered as of these records, it lives at a different address, 3965 West 118th Street. So that's the objection there, and that's where the record is. You'll see it on page 6.
Mr. Gessler, same argument as before?
Same argument as before. Person registered in Westminster, lives in Westminster, eligible voter to vote in Westminster, meets all the requirements of the code.
Ms. Parker. When you or your staff came across a signature that is difficult to read, what's the process you use to determine whether it's a valid signature or not?
Well, essentially, we had many people looking at signatures, so we would pass it around to one another and say, hey, can anybody make heads or tails of this? And we would do our best and exhaust all possible eyes in the vicinity to attempt to read anything that we could not read. That was essentially the process that we used.
And you were able to determine this particular person?
Give me just 1 second while I take a look here.
Thank you.
Just to be clear, we are on objection number 8. Is that correct?
Right. But in the and I think also that the petitioners indicated that in addition to having the wrong address, the signature was not legible. Is that correct? I don't want to put words into your mouth, Mr. De Herrera.
On this one, we gave the signer the benefit of the doubt, but the next on the signature. So we didn't judge his signature. We think it's there. The problem here is you can't confirm the registration based on what was supplied in the petition. You need additional information. So that's the thrust of the objection on number 8. But if you get to objection 9, that is a signature issue.
Okay. So you're still answering my question on the because this issue of illegibility and the ability to not identify the person because they can't read the signature has come up. So basically what I'm hearing you say is you're a whole lot of people look until you can determine.
Absolutely, unless no one could determine. There certainly were some final dispositions, I believe, very few, that were determined illegible because we simply could not determine, and we would also try in the database, we would use the Secretary of State's database to use their fuzzy search, if you will, where you can use a couple of letters, a couple of numbers of an address line. If we could determine even that many, we attempted to err on the side of the voter and find a record if we could. So in my memory, if it serves correctly, I believe that final dispositions of illegible signatures were extremely low.
So you started with the county clerk voter registration records in ineligibility, you used other options in the Secretary of State database.
That's correct.
All right, thank you. Mr. De Herrera, anything further on objection number 9, or have we?
No, Your Honor.
All right.
Oh, I'm sorry. Are we on objection? I would like to articulate on objection number 9.
I would like to ask a question on objection 8, Ms. Goldman, if I may, of Ms. Parker.
All right, go ahead.
Okay. Ms. Parker, I just have a quick question for you. So when reviewing the signatures, you saw it when possible to confirm that that was the proper person based on the name, if necessary, the address and the signature, correct?
Not on the signature. We did not actually have access to the Secretary of State's signatures, the images of signatures. So we were seeking simply to match a voter registration record based on the information we had in front of us.
Okay, that was where I was headed. The other question I have is, so there were some, and you say it was relatively low, but there were some that you rejected because of an illegible signature, correct?
That is correct.
So it wasn't just a gimme every time someone, put down something. You had to look for some way to verify that that was indeed an actual voter, correct?
We did.
Okay, I have no more questions. Thank you very much.
All right, Mr. De Herrera.
Okay, Your Honor. Objection 9, which is at the top of our page 6 and bleeds into page 7 of our exhibits. 2 issues here. We believe warrant ruling that this signature is invalid on the petition without further information. 1, we can't identify the name. Number 2, we're uncertain that that is a signature. I understand that the clerk has a desire to err on the side of allowing participation in a petition, but we do think that there is a bound to that, and we think this is over that line. So for those 2 reasons, that the person's name, the printed part of it, can't be identified, and the signature is problematic for us. And based with those 2 things, with those 2 issues or deficiencies, the person's voter registration can't be confirmed.
Would you consider the fact that even though you could not identify a signature or it doesn't look like a signature, that it might be possible that somebody else could?
Yeah, I could see how someone would use that signature, and that's not the main thrust of the issue with this one, but that is, I can concede that there are creative signatures for sure, but I can't tell what the printed name is.
Okay.
To confirm that this person's registered.
Okay. Okay, and it does appear that the city clerk and her staff were able to do that. Anything, Mr. Gessler, or?
Just very briefly, Your Honor. Look, I've long believed that.
Respond on all of them unless you really feel the need.
I've always believed that sometimes signatures are somewhat of a black art, and less than actual science. And I, even from my personal experience, now that we have the, those keypads for grocers and all that, I will tell you my signature itself has degraded substantially because it's just so hard to create a decent signature on those. And I have to resist the effort to have that similarly degraded signature when I use a wet signature for papers. But the fact of the matter is, signatures themselves are a very stylistic thing, similar, which uniquely identifies a person, and don't necessarily, in the signature itself, don't necessarily articulate every single letter in a perfectly legible way. That's why they're signatures. That's why you print on these, and that's why you also include an address. So there's multiple ways to identify a voter. So I understand Mr. De Herrera's argument But I do think it's appropriate to recognize that the clerk, as she has testified, has sort of a substantial level of review, multiple eyes on it, and properly so, that if someone's able to, interpret and identify that voter, they should be counted, because we don't want these technical type of arguments to disenfranchise voters from their ability to participate in petitions. So, thank you.
Thank you. All right. Mr. De Herrera, moving on.
Your Honor, we would move to objection number 10, which is at the bottom of page 7 and top of page 8. We would argue that this signature should be ruled invalid because the person's voter registration cannot be confirmed with the information supplied in the petition. There is no Darlene Abeta at 9823 Hooker Court in the voter records. What we've done on this one is we've inserted a screenshot from, I believe, the clerk's confirmation, which shows that there is a Darlene Abeta registered at 9210 Raleigh Street, which obviously is different than 9823 Hooker Court.
Okay, let's see. Get the right pages here.
Yeah, and so that's the top of page 8, bottom of page 7.
Okay. Yeah, I'm so confused. It was environmentally clean saving pages, and I forget to look on the back side. So I apologize for that. Okay. So you're saying that the address does not match, correct?
Exactly. Address does not match, and based on the information supplied, cannot be confirmed that this person was a registered elector.
All right. Gessler?
Your Honor, we'll stand on some similar arguments that we've made before and that you've heard before. For this particular signature and voter, we have provided an affidavit. So you should have that in front of you in the packet from Darlene Abeta. The protesters, I think, have helpfully and accurately reproduced section 1-1-104, subsection 35, registered elector. So you can look at that text yourself and confirm certainly the fact that it does not require, in order to be a registered elector or a signed document, it does not require that the printed address match the address in the voter database. Rather, it is a piece of evidence that allows the clerk or the reviewer, in this case, Clerk Parker, to identify that person as a properly registered voter. But we would say in this instance, this person was in fact and is in fact properly registered in Westminster, and they live in Westminster. You can see that on the face of the information that both you and the clerk have available. And then we also have provided an affidavit that the voter took the time to fill out to ensure that their voice would be heard. And you have that in front of you as well.
And we would just put our running objection, we would apply it to this one. Thank you.
Would it be fair to assume that that would apply in all cases, similar cases, your objection?
Yes, where Mr. Gessler is trying to cure with additional information, yes.
All right.
Thank you.
Objection 11 then?
Yes, objection 11, this is at the bottom of page 8, top of page 9. Here our objection is that the signature should be ruled invalid because the name and the signature are illegible and can't sufficiently provide information to confirm the person's voter registration.
Your Honor, Ms. Honorable Goldman, we'd incorporate the same arguments we've made earlier and apply them here as well.
And can I assume that in any further situations or circumstances where this argument has been made, that would be the case?
Absolutely, Your Honor. I'll, at least for clarity, for the record, I'll at least make that statement. And then if there's anything additional, I'll add that as well, Your Honor.
Okay. All right. Objection 12.
Objection 12. This is at the bottom of our page 9, top of page 10. We object to this signature. We believe it should be ruled invalid because the person's voter registration status cannot be confirmed because this name and that address is not found in the voter files. The address is incorrect. The address doesn't match. I don't know that it's incorrect. This could be a different person. It's just that address does not match a record in the voter file. And we've supplied the voter file screenshot below there on page 10.
Well, I am looking at that screenshot, and it shows the residence address as the same as the one that the Mr. Wheeler wrote on the petition. So I'm a little.
That's correct, and I think if you scroll down below to the second part of the screenshot under move history, as of up to October 19, 2020, this person lived at 1035 Jade Street, Broomfield. So this is, at the time he signed, it was the incorrect date. Now, this one is a little bit different than the others where you couldn't confirm it because that is in that move history is in the record that would be available to the clerk.
Mr. Gessler, any comments? And then
Ms. Goldman, I sort of, I actually interpret that effective date history differently. It looks as though he was registered on 6/11/2018 at 11766 Perry Street. And then it wasn't until October of 2020, after he signed it, that it was that there showed a change to Broomfield. At the same time, it shows a current registration address, again, of 11766 Westminster. So it's a little confusing, but under any approach, it seems though under his current address, it's the same. And up until October 19th, 2020, he was at 11766 Perry Street. So on its face, it seems as though he signed when he was registered at 11766 Perry Street.
So the way I read this is that it's clear that the signature was affixed to the petition on September 15th of 2020. I don't think there's an argument there. It looks as if on October 19th, there was a move made and a registration date also of October 19th. So the way I read it, and please let me know if you disagree, is that at the time of signing, Mr. Wheeler was at that residence. Yes, no? Either.
That's our interpretation.
Your Honor, yeah. The record is is unclear on several of these points. But what I'd like to distinguish is this one to Mr. Wheeler's benefit, at least in the voter file that the clerk could pull up to confirm his signature, they would have seen a record that this address at Perry Street is part of that voter's record. And that's some indicia that this person is that person otherwise registered, even though the dates, the addresses didn't match. So this one's slightly different than the others that we've dealt with, where when the clerk would pull up a voter's record, there is no indicia that that other address also applies or is associated with with that person who signed. So we would concede on this one that there is that extra indicia here that arguably weighs in favor of allowing this signature. Having said that, we do believe that all the information should be supplied, should be honest and trustworthy and accurate, and we think there is a deficiency with this one, but it's different than the other deficiencies that we've raised so far as confirming voter registration.
So are you going to drop this one, or are you going to continue with this?
We'd like to keep it on keep our objection on it.
Okay. Where are we on number?
Yes, we are dropping objection number 13 and number 14. Number 13 is on section 36, line 12. I believe the person's last name is Butcher. And that's for objection 13. Objection 14 is section 36, line 20. I believe that person's last name is Montoya.
All right.
So we would drop those two. And then we would proceed to objection number 15,
right,
which is at the bottom of our page 10. It starts at the bottom of our page 10. This is objection number 15 on section 37, line 4. We believe that this signature should be ruled invalid because required information is missing. This individual failed to provide an address or a county designation. So this signature is missing 2 pieces of required information and therefore should be ruled invalid.
Mr. Gessler, do you have any comments?
Certainly, we incorporate our earlier points. This person was, we're assuming that the clerk properly found this person because there's only one person by that name with that signature at the in Westminster. And then also we have provided an affidavit as part of the evidentiary record for your consideration.
Right.
To clarify, Your Honor, I believe the clerk testified that she cannot confirm signatures. She does not have access to that. So I think that was a misstatement by Mr. Gessler.
Okay, let me just, as a former clerk, let me just say a couple things about the term signature. It's used in and this could be apropos of nothing. I just want to clarify this. The term signature is used in a couple of ways in election law, municipal election law. When they talk about signature verification on petitions, what you are really talking about is matching name and address with name and address. However, signature verification is also used in mail ballot elections where the actual way people sign their name is compared against the way that signed signature appears in the voter registration database. So I just wanted to make that clear. As I say, it's pretty apropos of nothing, but people sometimes get confused when the term signature is used.
Thank you, Your Honor. That's helpful. And to make clear, we're not challenging the signature here. I was just raising that point because I believe Mr. Gessler was saying that was an indicia of proof of who this person was, that the clerk was able to confirm their signature. But I believe the clerk's testimony was that she doesn't have access to signatures, so she can't confirm that. But our objection here is that this person has failed to provide 2 of the required pieces of information, and therefore this should be ruled invalid.
Okay. Any further comments, Mr. Gessler, on this one?
No, we incorporate our other comments. And maybe I would say that your point helps illustrate some of the ambiguities in the election code.
Yes, indeed. Okay.
Your Honor, we will be dropping protest number 16, which was on section 37, line 13. I believe the last name is Jones.
Let me 16. Let me make a note of this. Okay, so now number 17 then?
Yes, Your Honor. Number 17 is at the top of our page 11 and goes into page 12. Our objection with this one is that we have problems with the signature, with the date. We don't think it's legible.
Just a moment. Mr. Gessler, comment?
Certainly, I think if you recall back the other date that was challenged, I mean, it looks as though there's a number of people who will leave the sort of top part of a 9 open when they're in a hurry. I think this is pretty clearly 9/29/2020, and of course that little gap in the 9's not quite fully connected, but we still think it's legible. And Ms. Goldman, if I may, and I don't think this, I just wanted to point this out for clarification earlier. There was an address, the one that we were talking about on Perry Street, and there was a later registration at Broomfield. My understanding is that Broomfield is a mailing address, but the actual address itself is in Westminster. So I would simply, depending on what other arguments develop, caution or note that sometimes a mailing address in the voter registration database may say a town outside of Westminster, but it is actually, in fact, inside of the political boundaries of Westminster, because the Postal Service doesn't always respect our political boundary names.
Thank you.
Back to the point on the whether the date's legible. I sort of agreed with Mr. Gessler when I first looked at this that it looks like 9/29, but then I looked at the first 9, which looks different than the second 9, and that was our point with this one. I don't think we need to dwell on this one, but just wanted to put that on the record.
Thank you. Let's see. Number 18 then?
Yes, Your Honor. Number 18, the top of our page 12. This is section 37, line 37. We are objecting to this signature because we don't believe there is a signature. It looks like the person was striking something and then initialing. So it's just it's a problematic signature in our perspective, Your Honor.
Comments, Mr. Gessler?
I'd simply say the signature, it is what it is, and it should be properly accepted. And we incorporate, of course, our earlier arguments.
Okay. All right. Number 19?
Number 19, Your Honor, is at the top of page 13 of our exhibits. This is section 37, line 43. We believe that this signature should be ruled invalid because the person cannot be identified and the voter registration therefore cannot be confirmed. The name is illegible and we couldn't find what we thought this name is in the voter file. So we could not, so without further information, we don't believe that this person's identity and registration can be confirmed.
So this is 3737. Is that no? I don't get my page. Sorry, get my page is correct. 3743.
Yeah, section 37, line 43 should be objection number 19.
Yes. All right. I'm just checking. Oh, okay. All right. Mr. Gessler.
Certainly, we incorporate our earlier arguments. The clerk certainly had adequate information to be able to verify that that person was indeed a registered voter in Westminster. And then also we have provided an affidavit filled out by this voter. .
All right. Objection 20 then?
Your Honor, objection number 20, this is the top of our page 14. We object to the signature. We believe it should be ruled invalid because the information supplied is illegible and we cannot identify the person's name nor confirm that this person is a registered elector.
Mr. Gessler, same comment?
Same comments. I would add that it's unclear, and I would simply urge, if you wish to continue to look at this after our arguments, to double check the actual petitions themselves and make sure that this isn't a problem with the copying.
Okay. I'm writing this down here. So. Okay.
Your Honor, we will drop objections 21 and 22. 21 is on section 37, lines 62 and 63. I believe the person's name is Bell Court. That was objection 21 that we've dropped. Objection 22 is on section 37, lines 65 and 66. I believe that person's last name is Ryan.
All right. Thank you.
We would move to objection number 23. This is at the bottom of our page 15. This is, we believe that you should rule that this signature is invalid because the date that the person has supplied is illegible. We can't tell what that date is.
Hold on just a second here, but Mr. Gessler, if you have something you'd like to say, go right ahead.
Certainly, our earlier objections, our earlier responses, we've incorporated those. There's certainly enough indicia here, and the clerk found that as well. With respect to the date itself, it seems to be 10/7/2020. The person wrote in the 7 in a much stronger, harder ink, and feels I can read it. The clerk certainly was able to read it, and so it should be accepted.
Okay. All right. Thank you.
We'll move to objection 24.
Mm-hmm.
This is on section 37, line 80. The problem we have with this one is we don't believe this signature has indicia of reliability. If you look at the handwriting, it seems to change. And I would point you to, Your Honor, the last name, Mangnall. It's got a very specific identifiable type of script that they've written in. But then you look at the word Westminster on the second line, it's very different. The M's are not close at all. If you also look at the date that's to the far right, I don't believe that writing matches the other writing. So there's a lot of indicia of unreliability. Now, this might be one where a petition committee could cure it, right? There is this indicia of unreliability that I think has to be addressed. And then you would tell the committee, well, show us an affidavit that this person, Mr. Mangnall, actually signed this and wished to participate in the petition. But I believe on the information supplied that day, it's an unreliable signature that should be ruled invalid.
Comments, Mr. Gessler?
Certainly, we would disagree with that characterization. Letters don't have to be formed the exact same way, and I know mine aren't necessarily that way. I would also point out that if that normally, and I think properly in this case, in order to be able to challenge that, we would need some form of expert testimony of a signature expert, or I should say a handwriting expert, to be able to testify that this was in fact, these were multiple different types of writing. And then finally, I'd submit the writing actually doesn't even have to be written by the same person. I mean, there are instances I know where a person has pre-filled in an address and simply signed another person signs their name to it, but in doing so essentially affirms the information. So there's actually not a requirement that the writing actually be consistent.
Do you have any legal backup or court cases or something that indicates that's the case?
I can hunt some down. I know I've been in administrative hearings before where that's been the case. So give me a little bit of time, Your Honor. If you need that, I'll work to get it.
All right. And Mr. Deher, you don't have any. Oh, sorry. Go ahead.
But if I will also say, again, in order to have that requirement, you need a statutory requirement for it. Absent a statutory requirement, it's simply not required. What you're looking for is, I think Mr. De Herrera properly, articulated a comment of, indicia of reliability. Now we obviously disagree with him here. We think there's plenty of indicia of reliability. The name, a signature, and I recognize that they're not, when I say written signature, a date, we have an address, and most importantly, we have an affidavit from the circulator saying that they saw this human being write this stuff down and affirm to them that this was the proper signature. So we can't ignore that item. There's more than simply a signature line here for all of these signatures. There's also a live human being, a circulator, who watched each person sign this. So there's more than just that. So anyway, that's our comment. But again, we disagree that the writing is so substantially different as to question the signature line. We just disagree with that.
Thank you.
Yeah, I would just, in brief reply, certainly there are affidavits by the circulators attached to all these petition signatures. If that were sufficient proof that all of these signatures were valid, we wouldn't be here. We wouldn't have the situations we've looked at today where there are people whose registration we can't confirm. So while I acknowledge that the certificate, the petition circulators have signed affidavits that say certain things, that can't rescue invalid signatures. And just to give one other example of what might have happened here, and I think, this is just speculation, but because of the sort of unreliable information, this is a possibility. It's possible that Mr. Mangmel filled this out, but left out the city and the date, and the circulator or someone said, oh, wait, you need to put that information in there. Otherwise, they're going to rule this invalid. And so someone else put that information in there. That's a real possibility with this signature. And that's why on its face, it should be ruled invalid. And then, if the committee could, they could try to rehabilitate it through an affidavit of Mr. Mangmel. That, I believe, is how the process is supposed to work when the signature is missing information or is unreliable. I would if there are no further questions or statements on that one, we would drop protest number 25, and this is on section 37, line 85. I believe this is Mr. Padilla. Okay, so we would drop that one. And then we would move on to our number 26, which is at section 37, line 87. This person, we believe that this signature should be ruled invalid because the information supplied is illegible. We cannot identify the person, much less confirm that this person is registered. There are parts of the information that I think you could read, but the name we cannot read, Your Honor.
We'll incorporate and rest on our earlier arguments.
Thank you.
If the court has no further questions, we would move to objection number 27, which is at the top of page 18 in our exhibits. This is at section 43, line 13. Here, this person's, we believe this should be ruled invalid because the person cannot be identified in their registration confirmed. Let me see if I have some more notes on this one. We don't believe that there's any Matt Stelling that can be identified in the voter registration records. And I apologize that we don't have the screenshot from the voter record here, but I can work to get that to you as soon as we finish here, Your Honor, if we take a break.
Mr. Gessler?
The same points as before. Obviously, the clerk or the clerk's staff was able to identify this person in the voter registration database. To the extent that the objection goes to a differing address, again, registered in Westminster, living in Westminster, they remain validly registered to vote and are eligible to vote in Westminster. So that's essentially a repeat of our earlier arguments.
And my notes on this, Your Honor, is that there is no Matt Stelling in the voter file. There is a Philip Stelling, but there is no Matt Stelling.
Do your notes indicate the address for a Philip Stelling?
I believe there's a Philip Stelling who is registered at this address, but there's no Matt Stelling registered at any address.
Okay.
Ms. Goldman, I would, and again, we're sort of shooting in the dark here, but I would simply note, and I'm sure you're aware of this, that sometimes people will sign or commonly use their middle name as opposed to their formal first name, or some variant of that. So I just posit that, and again, we're shooting in the dark here, so I'm just pointing that out.
So neither of you have any official information whether they're one and the same.
Correct, Your Honor, which makes our earlier point as far as can't be confirmed. The registration can be confirmed based upon what was supplied in the petition.
Okay. Well, we're likely to find that out. So,
and we believe they're clearly one and the same based on the clerk's interpretation. And again, there has to be some evidence to overcome that presumption, and at least we're not seeing it right now.
All right.
All right, Your Honor. We would move to objection number 28, which is at section 43, line 62. We believe that this signature should be ruled invalid because of conflicting information indicates that this signature is not reliable and the voter registration cannot be confirmed. We can read what the person wrote, but it's also clear to us, many of us who live in Westminster and live by this address understand very well that Highland Greens, which is a neighborhood in Westminster, is not in Boulder, Colorado. And people do make mistakes in the information they provide, but I'm not, it's hard for me to accept that someone would put the wrong city with their address. You know that you live in Westminster, you know that you live in Boulder, or you know that you live in Broomfield. So it just raises a lot of red flags. Now, I'm not saying that this might not be something that could be confirmed, could be cured through the cure process, but on its face, I think you have to look at this and say that there's something about this information that was supplied by the person that doesn't allow us to accept this as a valid signature with the required information.
Mr. Gessler, I believe there was an affidavit regarding this particular item.
That is correct. And then we would also point out that people make mistakes all the time. We wish that they wouldn't. We wish that people would sign things perfectly, never have the wrong town, never have the wrong county. But the fact that the Highlands Green, the specific information, is clearly a Westminster neighborhood, as Mr. De Herrera recognizes, shows that this person, does live there, properly signed it. Obviously, we have the affidavit as well. And certainly under substantial compliance standards should be accepted because we want to err on the side of, or when there's a minor error, we want to allow that person's voice to be heard and to be able to, whether it's voting or signing a petition, to be able to participate.
And Your Honor, we would just put on the record our running objection to the cure attempt.
All right. 31.
Yes, we would be dropping objection 29 and 30. And would you like the information on those?
Please.
It's at section 43, line 87. This is objection 29. And I believe her name is Heather Smith. And objection 30 is at line 43, section 43, line 96, Mr. Robert Schamberger. So we would drop both of those and we would proceed to objection 31.
Mr. De Herrera, could you just double check? I'm sorry. So number 29 is section 43, line 96. Did you say?
87. 29.
87.
Yeah. 29 is line 87. 30 should be line 96.
Are you Mr. Yes, are you questioning the line 96?
No, I'm just trying to get things in the right order, Your Honor. It's my confusion.
All right.
Maybe Mr. Gessler won't let us drop it. He wants us to.
You're more than welcome to drop anything you seek to.
So, all right, number 31 then? Objection 30.
Objection number 31 is at the top of our page, at bottom of our page 20. This is at section 44, line 2. This person, this signature should be ruled invalid because this person was not a registered elector when he signed the petition. And we've supplied the voter profile on the next page, which is top of page 21. And that information shows that this person registered on September 22nd, 2020, which is 2 days after he signed this petition.
Mr. Gessler?
Certainly. I don't think that's what the voting record shows. It shows that he was registered or affiliated. Well, in order to be affiliated, you have to be registered as of March 4th, 2020 as a Republican. And it looks as though his status was changed to active on 9/22/2020. That's what it looks like. Not that he was first registered then, but that his status was changed to active. And I'd point out that, this was accepted by the clerk and recorder during her review. Certainly if this person did not exist in the database, then I'm assuming they would never have accepted it, because I do not, despite the clerk's staff's capabilities, I don't believe they are clairvoyant and able to predict that someone will register at a particular address. So he was registered, and then simply it looks as though was listed as active on 9/22.
Your Honor, with all due respect to the former Secretary of State, I think the document speaks for itself. The person became registered on September 22nd, 2020 in Adams County. Whether he was registered, whether he was affiliated with the Republican Party, and his record shows that being, March 4th in a different county, we don't know that, and that's not the operative fact anyway. The operative fact is when did this person become an eligible voter in Adams County to participate in this petition? And that date is, as the document says, September 22nd, 2020.
Have either of you any information from? Well, let me back up and let me again ask the question. It's my understanding, and again, you can tell me if you don't agree with it, that the input into a voter registration database may or may not occur on the same day a person files a registration. Do either of you have, in other words, there might be a lag time. Do any of you have any personal knowledge as to how quickly the county clerk's office operates, or if what I am sensing is true or not true, or any of that kind of thing?
Absolutely, Your Honor. So what happens is usually there's it depends on the county clerk. Usually there's a few days lag, because what happens is when someone registers online, for example, to vote, or even submits a piece of paper, they register on that day, although they're not inputted into the database necessarily on that day. I mean, some clerks and recorders may do it on the exact day, but usually what happens, certainly the online registration, it comes in, goes through the Secretary of State's system. They then send through the SCORE system an opportunity for the clerk to review that. The clerk then reviews that registration and then either accepts it or rejects it. Usually, of course, accepts it. But that does not necessarily happen on the same day. And in fact, certainly in larger counties like Adams or Jefferson County, there's very frequently several days delay during the months preceding a general election, exactly like this one, because there's a larger volume of registrations, there's a larger volume of work, it's just harder to get to. So during the off periods, for example, rural counties, they may batch it and accept all of the new registrations, once a week. So there could be a delay there. Larger counties usually is only a 1 or 2 day delay, but those delays become larger prior to the actual, just prior to the actual election, which would be this exact same window. So, so the answer is absolutely not. They are not always registered the same, input into the system the same day that they actually register. And in fact, there's oftentimes several days delay.
One moment. So, Mr. Gessler, I know that on a couple of occasions you've included an affidavit from somebody who's indicated that they registered on one day and didn't show up until another way. Do you have such a affidavit for this person? I don't recall.
I don't believe we do for this particular person.
Go ahead, Mr. De Herrera.
If I may, with all due respect to the discussion, this is a black and white issue, and there's no substantial compliance. There's no, was there a justifiable excuse or a delay? The statute, the Constitution, the city charter, the city code are all very clear that to participate in a petition for recall, the signer has to be registered to vote when they sign the petition. That's a black and white issue. You are or you are not registered to vote on that day. And what you do, you have to look at the records, and the records are also going to be black and white on this issue. And here, the record is clear. County registration date, 9/22/2020. The effective date of that, September 22nd, 2020. That is after the date that he signed. So when this person signed, I believe it's a he. When they signed, they were not eligible to sign. So that is not a deficiency that can be cured. This person could say, well, I wanted to be registered. I tried to be registered. He could even say that he filled out a form to be registered. But none of that would change the fact of, was he registered on the day that he signed? If he was not registered on the day that he signed, that's a black and white issue, and that can't be cured, Your Honor.
Yeah, I would just point, I think Mr. De Herrera's interpretation is fundamentally incorrect. We have in Colorado same-day voter registration. The day a person physically registers to vote, is the day they are deemed to be registered to vote under Colorado law, regardless of whether or not a clerk and recorder enters it on that exact same day. And we do have delays, certainly through an online voter registration. There's delays if someone registers to vote at the DMV. But it may have been that way years ago, but since Colorado has moved to the same-day voter registration, I think that argument is just fundamentally incorrect.
Your Honor, my argument is not that he can't register on the same day. He could do that. Presumably, you could go to the clerk's office. You can register if it's not an election day, right? You go to the clerk's office, you can register, and right after you register, you can sign the petition that same day. That's not the argument that I made, and that's not the situation here. This is after. This is after the date that he signed, and on the date he signed, he was not registered according to the clerk's records. If we can't, abide by the clerk's records, then what do we have? I mean, the record is what the record is of the clerk.
Ms. Parker? Do you have any insight or any comments on this particular discussion? Anything that you are aware of? Any direct knowledge you might have?
It is my understanding that some voter registrations occur fairly instantaneously, and some do end up in an administrative pipeline that may not be reflected immediately. I do know that there is a delay in some instances in getting processed.
Okay. And we really don't know for certain which way it is in this one. I mean,
I don't have any extra information
Mhm.
on this particular one that I can offer you.
Okay. And other than the arguments, you have no proof of one way or the other, either of you. I mean, I understand each of your arguments. So,
Well, we believe we have proof, but yes, Your Honor, as long as you understand our argument.
okay. Thank you, Ms. Parker. All right, are we moving on to 32 then?
Yes, Your Honor, if you have no further questions, we'll move on to objection number 32.
Okay.
This is at the bottom of our page 21. This is section 44, line 5. Here is another objectionable date. We don't believe the date is legible. And that's our only objection to this one. And I believe that the problem with the date, not just that you can't read it, but the date is August 18th, which I believe is before the petitions were approved. So it's not just that the date is illegible, you can't read it. I think you can read it. You put August 18, 2020, and that is before the petitions were approved. Therefore, this is a problematic signature that should be ruled invalid.
Mr. Gessler?
Certainly, Your Honor, I think it's 919. And I would point out, I think what's going on here is that the person who forms their 9 starts from the bottom and goes up, which frankly is how I do it. And sometimes they get squished like that, as opposed to, starting at the top with a circle and then the strike down. It starts the curve at the bottom and comes up, sort of like as if you're writing a 6 in the upside down format. And I think that's exactly what happened here, but it's 919, and I think that's pretty easily read.
Okay. All right. Moving on, Mr. Dyer,
we would disagree that that's 9, and we would believe that this would require a cure and could not be approved on its face based on the information supplied. We have moved to objection number 33.
All right. Please go ahead.
Thank you. Objection number 33. This is at the bottom of our page 22, section 44, line 19. Here we have another illegible signature that's problematic for us, and we believe that the signature should be ruled invalid because of that. And we won't venture to guess what the numbers are. We just can't read them.
All right. And
we believe that requires a cure.
That looks like 9/20/2020. I mean, the 2s are not how I write them, but it seems pretty clear that that's what they wrote. And you can tell, particularly because of the year 2020.
Okay. All right.
All right, we'll move on to our objection number 34. This is at the bottom of our page 23. This is signatures found on section 44, line 31. We believe that this signature, although maybe it is a black art, as Mr. Gessler says, we have a problem with it. We don't think it's a reliable signature. I believe that's my only objection to this one.
Could you define reliable in this particular instance? What do you
it looks like it looks like 3 different things going on in this one, Your Honor. And, it's hard to define, like they say sometimes it's, it when you see it. And this one looks highly unusual. And that's why we have the problem with it.
And can you read the printed name?
Yes, I believe I can read the printed name. Miss Jackson, I believe. Holly.
Thank you. Mr. Gessler.
Your Honor, I think it's a fantastic signature worthy for a place on the Declaration of Independence.
Or a medical personnel, perhaps?
I'd say it's much better than a prescription signature. Let me put it that way.
We digress here. Okay.
Yes, we do. I would move on to objections number 35 and 36. This is at lines on section 44, lines 32 and 33. We believe the signature should be invalid because the form is improperly completed. Let me look at my notes here. I think this one is, we're highly suspicious that one person made both of these signatures, and that would certainly be illegal and render at least one of these invalid. So that's our dispute with this one.
Comments, Mr. Gessler?
Just one moment. I'm just checking my notes. So my understanding, the objection was that it's improperly signed, but it's, if I understand correctly, there's two objections. One, that the form itself, I guess, when you say improperly completed, I just don't understand that. And then there's a suspicion that the same person filled out both lines.
Yeah, it's all the same. We believe one person filled out both lines, and that's illegal and renders them, at least one of them, invalid. Okay.
So I guess my response is, on the face of it, you just simply cannot make that supposition absent an affidavit from a witness who says that the same person filled it out, or a handwriting expert that says the same person filled it out. And then on top of that, the fact of the matter is, voters can and do allow witnesses to sign for them. That's allowed in voting, and certainly as well in the petition. Now, I'm not sure that even happened. I'm not even saying the same person did this. But what I am saying is, right now, I don't see any actual evidence, that this was the same person, or that it was illegally done.
Any further remarks on this, Mr. De Herrera?
No, Your Honor.
Okay.
We are dropping objection number 37, which was at section 44, line 36, Mr. Steve Owen.
Okay.
We would move on to objection number 38. This is at the bottom of our page 25. This is at section 44, line 38. Here, this signature should be ruled invalid because this person was not a registered elector when he signed the petition. And the evidence of that is on page 26 with the voter screenshot from the voter profile report, which shows that this person, like the other one we discussed a few minutes ago, his registration, I believe it's a he, his registration with the county was on September 22nd, 2020, but he signed the petition on September 20th, 2020. So he was ineligible when he signed.
Let me write this down here. And we already discussed a possibility. Mr. Gessler, do you want to say anything further?
Yeah, Your Honor, or Ms. Goldman, something's going on here that's unusual, because if you look at this effective date, 9/22/2020, on both of those, it's the exact same date as the earlier one. And what that leads me to believe that there's some type of batch processing going on here. So in fact, there are probably, delays. I don't know how substantial they are, but I think you can create a very strong inference that there's substantial delays going on, and that there's due to some batch processing here. The other thing that I'm not quite understanding, and again, it seems a little bit strange here, is that so it looks as though he was registered in Broomfield as of 2016. Now that says Broomfield, it very well may be a Westminster address. And then on 9/22, it says Louisville down at the bottom. But at the same time, that seems to contradict the earlier, the address date above, where it says Raritan Court in Westminster. So something strange is going on here. I'm not exactly sure what it is, but I would be highly suspicious that this voter profile report, in fact, conveys the information that that council is representing that it conveys.
Your Honor, I would just point out that that's a lot of speculation. I think what the records clearly state, unambiguously, is that this person's registration date with Adams County, which is the operative fact here, is September 22nd, 2020, which is after the date he signed.
All right.
And if I just may point out, I think this is where it's important. We can accuse one another of speculation. We're interpreting what this document may or may not be. This isn't the original database itself. It's not necessarily those dates are the ones the clerk reviewed, because the 9/22/2020 date may or may not have been in the database that she reviewed. And at the end of the day, the protester has the burden of providing that evidence. So I do think this is where the burdens come in, and it's important to understand who has the burden of not just production, but also persuasion here.
Moving forward.
Yes, Your Honor. We would move on to objection number 39, which is at the bottom of our page 26. Objection 39, this is section 44, line 54. We believe that this signature should be ruled invalid because the voter registration cannot be confirmed under this name as supplied by the person who signed. My records indicate to me that there is no Jan Brace that can be found in the voter registration file.
Mr. Essler.
Well, we'd incorporate our earlier comments as well, and we also have provided an affidavit for this voter for you to review. And again, I would note that, and again, I don't have that in front of me right now, but to note that, we do have variants of names, and especially people will use their middle name. We actually reviewed that earlier one that we were talking about, Patrick Matthew Wheeler. And I think we determined that his middle name was Matthew, so that any signature with Matthew, I think it was Wheeler, was in fact a middle name that was used. So I would simply caution or note that could be an explanation, but we do have an affidavit.
We would just put our running objection on the record to Mr. Gessler's attempt to cure the deficient signature.
Okay, all right. 42, is that correct?
Yes, we would go to 42, which means we are dropping objections 40 and 41. 40 is section 45, line 55. I believe the person's name is Sheila Ruckstuhl, Ruckstuhl.
Okay.
And for objection 41, that's section 45, line 60. The person's name, I believe, is Jerry Hersey.
Okay.
So we're dropping those, and we go to objection number 42. Here we believe that this is section 45, line 76. We believe that the signature should be ruled invalid because the person cannot be identified and his or her voter registration cannot be confirmed because the name as written is illegible.
Mr. Mr. Gessler?
I'd simply say the name is legible. The clerk was able to, or the clerk's staff, I should say, was able to identify the voter with that name, and they were able to read it, and it was properly accepted.
Okay.
Your Honor, we would move to our objections number 43 and number 44. And let me take a look at my notes here. Here we have a similar objection to what we had before with 2 signatures and pieces of information. We believe that one or both of these should be ruled invalid because the writing is too similar. We believe this is the same person who wrote and signed these 2 entries in the petition.
Yes, Mr. Gessler?
Certainly. The signatures are much different. Yeah, I mean, I think the signatures are much different. And again, when you look at sort of the do's and don'ts of what a person's allowed to do, they're not allowed to sign for another person, but they still are allowed to render assistance. So, and I'm not even conceding, and I don't believe that the writing is the same. I mean, there's some similarities, but there's some very certain differences as well in the printing throughout this. I mean, if you look at Adams, the county where it says Adams, the capital A's in the Adams are much different with those, with the people who signed those, or wrote that in, I should say. So, I mean, if you look at the date, the 2's are different that they wrote in. If you look at the S, the capital S in Sarah Helms, that's much different than the S's that were written in Chaz and Helms, the last letter. So they're different, and the signatures are certainly different, and they were properly filled out. And then again, we have the last item of indicia that the circulator who watched every single person sign, signed the affidavit that they did, there was not a single person who signed both of these.
Okay.
Your Honor, we would move to objection number 45.
All right.
This is at the bottom of our page 29 in the exhibits. This is at section 51, line 40. We believe that this signature should be ruled invalid because this person was not registered when she signed the petition. And if we go to the next page of the exhibit, we've included the snapshot or screenshot from the voter profile report for this person. And it shows that her county registration date is October 21st, 2020, whereas she signed the petition on October 10th, 2020. So at the time, she was not a registered elector as is required by law.
All right. Mr. Gessler.
So we would incorporate our earlier comments and earlier arguments with respect to the database and ambiguity in this voter profile report and the lag. And then we've also included an affidavit too.
All right.
Your Honor, we would move to objection number 46, which is found at the bottom of our page 30. This is at section 51, line 65. We believe that there is, that this should be, one or both of these should be ruled invalid because if you look at line 65, one, it looks pretty clear to us that the same person filled both of these signatures out, 64 and 65. And if you look at number 65, there's a, under where it says city, POA. So I believe that one of these folks, maybe it's Amy or Ann, has a power of attorney and is trying to sign for this other person. but there's no indication on the affidavit that was verified. And we believe that would be required of the petition circulator to verify that power of attorney is in effect and grants the authority for person signing, that they have that authority to sign this political document. So that's our objection to number 65.
Mr. Gessler?
So it definitely looks like a power of attorney. I am unaware of any statute, regulation, ordinance, or anything that requires a circulator to actually demand power of attorney documents as part of a signature. It just doesn't. I mean, that's maybe it's a good idea policy-wise, maybe not, but it's simply not required. And the reason people grant and have powers of attorney is so that they can do things like this and do signatures on behalf of people. And it was properly done here. And there's simply no statutory requirement or authority. And then finally, I would say, to the extent that it's an interpretive requirement, that it's a matter of interpretation, the clerk interpreted it, in fact, to allow this to take place.
Your Honor, if I could reply, it's a basic requirement for a notary here in Colorado to confirm that when they sign and notarize a form, that the person who they're affirming signed the form, they have to confirm that. And so when you have someone who's signing for someone else under a power of attorney, the notary needs to verify that. They need to have a copy of it. And the best practice is they should include it with their notarized statement. But at a minimum, the notary has to confirm that the person who they're affirming a signature is that person. And so in the case of someone who's signing with the power of attorney, they have to confirm that they have that power of attorney. It's the same basic requirement that's in the circulator's affidavit that they swear. I affirm that the person who signed this form is that person who represented themselves to be. And so when someone is signing someone else's name, you can't affirm that if you're the circulator unless you've confirmed that, yeah, they are the power of attorney, because that's what their affirmation is confirming, that this person, Miss Ann Jensen, has the legal authority to sign for Mr. John Jensen. And that is not in the records, Your Honor.
If I may respond, these signatures are not notarized. The circulator is not a notary public. These are not notarized. The framework for notaries does not apply. Simply doesn't.
I agree, it doesn't apply, but it's
so the arguments are irrelevant that the circulator, that this person had to present a power of attorney as required by notary requirements for a circulator affidavit. They are two different things. And right now what we have is speculation that this person wasn't in front of them or whatever, without evidence. I think if you're going to strike this, you need evidence, and the evidence is not on the face of this. You need evidence, just as we're providing affidavits, evidence from a witness who says, no, this was improperly done, or you knock on the person's door and they say, yeah, no, I goofed, or you knock on John Jensen's door and you say, hey, John, did Ann have the authority to sign for you? And he says yes or no under oath. I mean, that's the type of evidence we need here if this is going to be struck. And we don't have that evidence here to overcome this presumption at all.
Your Honor, if I could just be real brief, I think Mr. Gessler has it backwards. The petition on its face has to be valid to meet the requirements of the statutes. And when the information is not supplied with the petition to confirm that the signature is valid, that it meets all of the requirements, then it has to be cured if the committee can cure it. And that's the case here, because there is nothing in the petition that was submitted to demonstrate that this person has the authority to sign for who she signed for. It's not in the petition, and so that is something that would need to be cured, because you can't confirm that just on what was included in the petition.
Okay, I have a question of Ms. Parker first, and then a question of both of you. Ms. Parker, could you please identify what your thinking was, or what you did, or what your staff did here, if you can remember?
I'm sorry, I can't offer you any kind of memory about this specific set of lines. I certainly was not the person, or did not have any memory of being the person who verified and processed these lines. I apologize, but I don't have anything to offer.
So my question is, and thank you. So my question for either of you, or both of you, Mr. DeHerrera and Mr. Gessler, is due to the fact that I am not an attorney. So while Mr. Gessler indicated that there is no statutory requirement that a circulator demands some kind of certification or authority from a power of attorney, but that people who have power attorneys can do things like this, my question is, does things like this apply to signing an election petition? Because I'm aware of the fact that I know that if you have power of attorney in a mailed out election, you cannot sign a person's name, even if you have that power of attorney. So that's my question. And I'm not an attorney, I don't know the answer. I just want to know if you have any legal understanding as to whether the power of attorney can be applied in this particular election situation. Do either of you know?
Well, Your Honor, I think it goes back to the basic principle is, can you look at the signature on its face to confirm that it meets the requirements of the statute? Did this person sign it? The date, can you use the date to confirm that it was signed in front of the circulator? Does it include all of those information? And so on this form, Ms. Ann Jensen signed this with POA, and that needs to be verified because it's not in the records that are available to the clerk. The clerk can't go to a master file and say, oh yeah, there's the power of attorney. It's information that has to be supplied. And so I think that's why this one should be kicked to the cure process. And then Ms. Jansen can say, yes, I have the power of attorney. It's broad. It covers everything, including voting rights. And here's a copy of it. And that confirms that this signature that I did on that day was effective and met all the statutory requirements.
But my question isn't whether the power of attorney was certified or not. My question is, can somebody with a power of attorney sign someone else's signature on a recall petition? That's my question.
It would depend on the power of attorney. The power of attorneys can be broad enough to cover that, or they could be limited. I'm not aware of a statute that says someone cannot use a power of attorney to sign a petition recall.
So, and I would generally agree with that statement. I think powers of attorney apply to anything, unless there's a statutory prohibition on that application. And there's not a statutory prohibition on this particular application.
Well, unless the power of attorney is going to speak for itself, and it's going to say you have power of attorney to do financial matters, real estate matters, or it could be broad and say all matters. So at the first instance, we have to see what the power of attorney says, because it could be a limited power of attorney.
The enforcement mechanism for that is if Ann Jensen improperly signed, she is subject to criminal liability. That's the enforcement mechanism. The statutes, the rules, the regs don't require, and nowhere that I have seen ever in the election context where someone has to produce additional documentation. I mean, look, if you're a witness or someone who puts a mark on a mail-in ballot, you're not required to provide documentation that person that you in fact witnessed or did it in front of a notary or something like that. It's the face of the document. The assertion that you're a witness is sufficient. Likewise here, the assertion that you're a power of attorney and you have that authority is sufficient. And that's exactly what happened here.
Your Honor, as a general matter, that's correct, right? The circulator didn't ask for everybody's driver's license. But in this case, the question is a serious one because Miss Ann Jensen had to put on there POA because she is not John Jensen. So she has to allege that she has the authority. But what my point is, and I think an important point is that needs to be verified. Had she had that with her and shown it to the circulator could have put the notation on there above his or her signature that says power of attorney by Ann Jensen to sign for John Jensen was confirmed. And then the clerk would have on the face of the record sufficient information to say, okay, this person, the circulator who affirmed that Ms. Jensen had that power of attorney, then you have on the face something that you could say is valid. Here we have a question that needs further information to confirm because I don't believe that the circulator saw the power of attorney, and I think it needs to be confirmed.
Yeah, I just say this is a new verification regime that has never been applied in the past and has no basis in the Colorado statute or law. Mr. Herrera is correct. D. Herrera is correct that the circulators are not required to verify identity through a driver's license or even any documentation whatsoever. That's not a verification requirement. There is not a verification requirement, and this would be adding something entirely new.
And the difference is because she's signing for someone else.
All right, I think I have enough information to muddle through this when I go through my findings.
Thank you, Your Honor.
I appreciate both your arguments. Thank you.
Madam Hearing Officer, and for those who can't see this disembodied voice, is Matthew Munch, Assistant City Attorney again. Any chance we could request a brief 5-minute recess just to use the restrooms and
Sure,
witness a moment?
that would be fine. So it is 11:21. Why don't we come back at 11:30? But before we do, I just want to get a sense of where we go from here. We're coming very close to the end of the discussion on the individual signatures. So the remaining item deals with a single petition which has some page inconsistencies. It would be, and I'm guessing that, and you'll have to let me know, that it won't take a huge amount of time to discuss that, arguments on both sides. And since Mr. De Herrera said you would not be considering item number 3, I'm wondering that after we take this break, which will take a little longer than 5 minutes, we would just come back, finish the signatures, go to that first item on the one petition section, make your final remarks, and be done with the hearing itself. Does that sound reasonable, Mr.? I know that you have witnesses, Mr. Gessler. I don't know if you plan on calling them or if they have anything to add that hasn't already been said. So just sort of give me a sense before we take this break. And that will determine how long this break will be.
If you want me to go first, Your Honor, I think your characterization is fair. I think we'll keep going at the same pace, maybe faster, since we've dealt with many of these. And I don't believe that the discussion on the bulk challenge will be very lengthy.
Mr. Gessler, your comments?
My sense is that's the same. I listed 3 witnesses. I do not anticipate calling them. Maybe something will happen that will change that. But at this point, I don't anticipate. Although I guess my question is Ms. Stimson planning on testifying? And that could change my analysis as well.
No, Your Honor, we don't see the need for live testimony by Mr. Stimson.
Okay. All right. Well,
that's different.
Let's take a fairly substantial break. Now it says 11:23. Why don't we come back at 11:45? We'll continue with the rest of the signatures, deal with the issue number 1 on what you call the bulk signatures, petition section number 33, and then we can you guys can make your final arguments. We can conclude, and then it's up to me. Okay?
Thank you.
right.
So we'll break until 11:40,
11:45.
11:45.
Yes.
Thank
All
you.
right. So we're now in recess. Thank you. So I think we are back. Mr. Gessler, are you available?
Yes, I am.
Great. Okay. So we are back in session at the hearing, and I believe we are on objection 47. Is that correct, Herrera?
Yes, I believe that's correct, Your Honor.
All right.
Ms. Goldman, before we start on that, if I just may say, we do plan on one rebuttal witness, total maybe 5 minutes of testimony, with respect to objection number 46, the power of attorney issue that we just discussed.
Well, then why don't we, is your witness available now?
She's not, but she should be available in just a few minutes, in hopefully just a few minutes.
All right. Well, why don't we, before we get too far afield, why don't we proceed to the next objection, and then when your witness is available, then we can go back, and that way we won't get too far away from the initial discussion.
Okay, that sounds great. Thank you.
All right. Mr. De Herrera, please go ahead.
Yes, Your Honor. Thank you. I believe we're at objection number 47.
Mm-hmm. Yes.
Our objection with regard to number 47, which is on the bottom of page 31 of our exhibits, this is at section 53, line 2. We believe that this signature should be ruled invalid because of conflicting required information, indicates that this is an unreliable signature. According to property records and city records, this person's address is in Jefferson County, not Adams County, and they listed Adams as their county, and that's required information.
Okay. Mr. Gessler?
I submit that that's a very minor error. Again, in the town of Westminster, the county boundaries, not everyone knows their exact county boundaries. I don't think there's any question that this person is in Westminster at an address in Westminster with the name at that address in Westminster. The fact that they erred in writing down the incorrect county, I think is irrelevant, and easily meets the signature otherwise easily meets the substantial compliance standard.
And Your Honor, just in reply, we don't believe any of the required information is irrelevant, and we believe this would require a cure by the person here who submitted the information.
Okay. All right.
We would move then to objection number 48, which is at the bottom of our page 32. This is in section 53, line 3. We believe that this signature must be ruled invalid because the person who signed was not a registered elector when he signed the petition. If you look on page 33, we have a snapshot of the voter profile report that we received. This one is from Jefferson County. And according to the Jefferson County Clerk's records, this person became an active registered voter on October 11th, 2020, which is several weeks after he signed the petition. He signed the petition on September 24th, 2020.
Mr. Gessler?
I would simply argue, I mean, I'd rest on our early arguments and our conversation with respect to the delay, but also I would urge Ms. Goldman that you go to the original source document rather than seeing this copy to see exactly what the voter registration database says.
All right.
And if Mr. De Herrera is finished with this particular objection, we do have a witness available to discuss objection number 46.
May we go back to item objection number 46, Mr. De Herrera?
Your Honor, I'd be happy to if that's your preference.
Yeah, okay, great. All right. I'm not going to pronounce your last name correctly. I'm convinced.
It's actually Ms. Christine Ireland.
Oh, okay. All right.
Your
So-
Honor, I would ask, is she on the witness list?
Yeah, she's not on the list. I was a little concerned about your kind of generic other witnesses as required type of notice.
Your Honor, I would object to the witness. I mean, it was clearly stated to us, and we've tried to abide by that. And you've mentioned it as well. This is a summary hearing that is supposed to proceed according to the rules that you and the city have established, and this person is not on the witness list. So, unfortunately for the witness, she's not able to testify today, in my opinion, and that's our objection.
If I may respond, we specifically said rebuttal witnesses, and the reason we did is because we cannot entirely anticipate every single argument that's going to be presented. So, for example, if you look at objection number 46, it says, because the circulator's affidavit doesn't indicate that the power of attorney was verified at the time of signing, that's an argument that we need to be able to rebut. And I specifically said that we would have rebuttal witnesses as a general phrase, rather than going through every single item and listing dozens and dozens of potential witnesses. Every court case I've been involved, even in formal court cases, listing rebuttal witnesses is perfectly acceptable to allow people to testify. Because look, the ultimate purpose here, I would say, Ms. Goldman, is to get a full picture of the evidence before you, to truly understand the truth of the matter. That is the purpose of these administrative hearings. And I recognize that the protester has sought to constrain and limit our ability to provide evidence at every turn, but that is not in keeping with either practice, the way this should go forward, and we're asking for 5 minutes of testimony.
Your Honor, if I could just respond, and I won't belabor the point. Mr. Gessler filed a motion to intervene in his witness list, and he said on there that he was going to serve the motion on me. Had he served the motion on me, that would have been one thing, and then I could have put on my witness list that will have rebuttal witnesses, and then I could make the argument that Mr. Gessler just made, that I could bring anyone I wanted in who I thought I needed because of how the hearing went. But that's not how this is supposed to work. Mr. Gessler and his clients have been on notice as to objection number 46 since the beginning. So we object to the broad claim that Mr. Gessler has that he can bring any rebuttal witness in because of what has happened at the hearing today.
All right, so here's what I have to say about this. Remind people that we're not in a court of law. I'm not, Your Honor, although I appreciate the honorific. This is an administrative hearing. I did indicate at the beginning in my opening remarks that I have the sole ability to determine what testimony and what evidence I will use in making my findings. I will allow this person to speak and only this person to speak, and then we'll evaluate the relevance of the testimony and how that plays into my findings. So, but that's it, Mr. Gessler. No, nobody else, okay, that isn't already on the list. So,
Your Honor, I'll push back in there, Ms. Goldman. I'll push back in the event. Look, I'm not planning on anyone else, but in the event there's some surprise where it's appropriate to have a rebuttal, I'm not going to concede that. I will tell you right now, I have, and you're welcome to rule against me as you see fit, but I am not at least agreeing to that.
okay, your disagreement is duly noted. So, all right. So I am going to ask you to raise your right hand and when to be sworn in. And do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name and then spell it for the record.
Christine Ireland. It's with a K, Kristine, Ireland, Ireland.
Spell your first name again, please.
Kristine.
Thank you. Mr. Gessler.
Is there a possibility, well, let me ask this. Ms. Ireland, do you have by any chance in front of you the exhibits for the hearing at your location? I'm trying to avoid a screen share if at all possible.
No, I don't have them here with me.
Okay. Ms. Goldman, I'm not sure how to share screens if the city.
What do you wish to share? Are you
just to show her the two signatures?
All right,
those two lines.
Let me be very low tech and do it this way. Okay. I don't know if this will make any a
field expedient measure. I think that works great. Ms. Ireland, can you see that?
Yes, I do see it.
Okay. Were you the circulator who collected those signatures?
I was, and I recall this one because it's the only time it happened. The lady brought a power of attorney for her father.
Okay.
It never happened any other time.
Can you describe what happened, please?
She came with a power of attorney. She said she was signing for herself as well as her father, who, for health reasons, and I'm just guessing it's because of COVID. He was older. He didn't want to come out and sign on his own, and she had power of attorney for him.
Did you look at the power of attorney?
I did.
And did you satisfy yourself that it allowed her to sign for him?
Yes.
Okay.
Yes.
And you saw her write her signature down as well, correct?
Right.
And you saw her write his signature down, is that correct?
Yes, she wrote his signature.
Okay. I have no further questions.
Your Honor, if I could respond, and I don't have any questions for the witness, so I think the witness can be excused unless Your Honor has any.
I have no questions.
Okay. You have.
Thank you, Ms. Ireland.
Your Honor, I would say thank you to Mr. Gessler for making my point. He needed to bring in additional information to cure what was not apparent from the petition that was submitted to the city. What he went through was a cure of information that was not sufficient to meet the statute, basically. And that's an appropriate thing to do when a committee has the opportunity to make a cure. But as I've said before, and we'll just keep on the record, that is not what is the purpose of today's protest.
He's trying to throw out names that he can't read.
Whoever's got their computer audio on, please turn it off. Thank you so much. Okay. Are we back to number 49, Mr. De Herrera?
Yes, Your Honor. Let me scroll down to 48.
Actually, Your Honor, if I may say, for number 48, we do have an affidavit for that.
Oh, okay. You have an affidavit for, okay. All right. Anything else on 48 before we move on?
No, but we would put our running objection on the record for 48.
Duly noted. 49 and 50 then?
Yes, Your Honor. 49 and 50. This is the top of our, the bottom of page 33 in our exhibits. This is objection 49 and 50, section 53, lines 7 and 8. We believe that these signatures should be ruled invalid because we believe that they're unreliable signatures. We believe that this was filled out by one person in violation of the statute. That's our argument on this one.
Mr. Gessler?
Certainly. There are a lot of the same arguments that we've made before. I will point out here the two signatures, the actual voter signatures, are clearly different, and there is no prohibition on filling in information for someone outside of the actual signature. So they can fill in other information on the signature line as opposed to the signature itself. And that makes sense because what we want is the conveyance of information, the printed name, the address, and date and whatnot. And it doesn't necessarily have to be in the voter's absolute handwriting. You can't use ditto marks, and you can't sign for someone else except in the instance of like this POA that we've seen. But these are certainly two different signatures. And I'm not really sure that the writing is the exact same, but even if it were for the printed name and address, that would not matter as long as the voter's signature itself is different.
Any further comments, Mr. De Herrera?
No, Your Honor.
All right, so number 51 then?
We would move to objection number 51, which is at the bottom of page 34. This is from section 53, line 11. We believe that this signature must be ruled invalid because the person signing their registration status cannot be verified in the voter profile, in the voter records of the county. There is no person of this name at that address in the voter file. So on its face, the person's voter registration status cannot be confirmed without further curing information, if that's possible.
Okay. Mr. Gessler?
Certainly. If you look at the bottom of the voter registration on its face, it does show that the residence is in Westminster. And again, registered voter in Westminster, an address in Westminster at the time. It is appropriate for this person to sign because they were registered and they resided in Westminster.
One moment, please. All right. Okay.
And we would just reply with our similar arguments from before. This person at that address, their registration cannot be confirmed based upon the clerk's records.
Okay. All right.
We would.
Go ahead.
We will be dropping objection number 52, which is in section 53, line 37, Miss Mary Williams. We will also drop objection number 53, which is also in section 53, line 44, Miss Montano. And we will also drop objection number 54, which is in section 53, line 47.
Okay.
Mr. Knight with a K at the beginning.
Okay.
Okay,
So
then
now 55 and 56 then?
Yes, Your Honor. 55 and 56. This is in section 53, lines 50 and 51. We have a similar objection that we've raised before. We think that the handwriting and signature are too similar, and we believe that it's one person who filled out and signed these two lines. And on those grounds, we would ask that one or both of these be ruled invalid.
Mr. Gessler?
We make the same points as before. And again, I would note in particular under where it says signature of voter for Mr. Michael and Ms. Nicole Hall, that those signatures are clearly different and in much different handwriting. And then also to us, to my mind, the dates are pretty clear, 10/10, 2020.
Okay. Next.
Your Honor, we would move to objection number 57, which is at the bottom of page 36. This is from section 53, line 55. We would request that you rule this signature invalid because this person was not a registered elector when she signed the petition. If you look on page 35, we have a screenshot of the voter profile that we received from Jefferson County Clerk. This shows that the person signed on October 10th, 2020, whereas the county records indicate that she registered with the county on October 16th, 2020.
Mr. Gessler?
Same points before we incorporate with respect to the lag time, as well as the uncertainty that this voter profile report contains the entire record or the exact same record as the voter database itself. So to the extent you feel you need to investigate this further, we'd urge you to look at the actual voter database rather than this this printout, purported printout in front of you.
Your Honor, we would drop our objection to objection number 58. This is from section 53, line 62, Mr. Wild Haber.
Objection 59.
Yes, Your Honor. Objection number 59, this is at the bottom of our page 37 from section 60, line 2. We believe that the signature on the signature should be ruled invalid because the date of the signature is invalid. If you look at the signatures and the dates on this page here, you have October 2nd, and then you have someone who signs October 3rd in between those dates, in between those other signatures. And we believe that requires a finding of an invalid signature for that person who signed this on October 3rd.
Mr. Gessler.
So with respect to the date, my understanding was the objection was originally illegible date, but obviously we're certainly prepared to argue this. There's not a requirement that the dates all be in sequence, only that they be a proper date. And in fact, it's not unusual for a voter to erroneously skip a line and sign one line down before, and then for the circulator to go back and present to a voter at a later time the gap for that voter to sign. And that's oftentimes how you'll get dates out of sequence. What's required under the law is that the date be a valid date within the time frame of the circulator petition window. And October 3rd was within the time frame. So the fact that there's a October 2nd before and October 2nd after is not a violation. It's not unusual for there to be a gap that gets filled in later, as long as the date on the signature line itself is correct.
We would disagree and argue that would require a cure by either the person on the second line or the third line to confirm that, yes, we did sign, we just gave the wrong date. So we believe it should be ruled invalid.
Okay. All right. Number 60.
We would move on to the objection number 60. This is the bottom of our page 38 from section 61, line 6. Let me check my notes here. This is a similar argument to the one we just raised, which is that the person signing on line number 6, Mr. York, I believe, He signed on 9/20. But then if you look on the next page, and this is all on our page 39, if you look at the next page of the petition, you have people signing on 9/19. So we think it's the invalid date problem that would need a cure.
Mr. Gessler?
Same arguments as before. This signature doesn't need a cure because it's valid to begin with. 9/20 is a valid date, and it was signed on 9/20. There was likely a gap that was filled in again where a voter erroneously skipped one, and as I had mentioned before, that's not unusual to happen in petitions when you have tens of thousands, well, in this case, thousands and thousands of signatures. As long as the signature line itself has proper date on it within the framework, that's acceptable. The dates in the petition themselves do not have to be in sequence, and there's absolutely no requirement, and that would be creating a new requirement, and frankly, a very technical requirement where none exists.
We have nothing further on that one, Your Honor.
All right, moving on then, please.
We move to objection number 61. This is section 61, line 76. We believe that the signature on line 76 should be ruled invalid because of an invalid date. We can't see that there is a date there. There's part of a date, but not the full date.
Mr. Gessler?
We think there is a full date there, actually. If you expand it and you look at the word county, you'll see that the top half of the 3 overlaps with the O in the U. And then the bottom half of the 3, part of that overlaps with part of the signature. And then you have the bottom part of the 3 extending. But if you expand it, you can actually see that there is a full 3 there, even though it overlaps with some of the other writing.
We'll just put on the record that we don't see that, Your Honor.
Yeah, I had to expand it to be able to see it pretty clearly, but I think if you expand it, you can see it pretty clearly.
All right.
We would move to objection number 62. This is at the bottom of our page 40. This is from section 68, line 22. We believe that this signature should be ruled invalid because the person cannot be identified and their voter registration cannot be confirmed under this name. As signed, it appears to be an Amber Gonzalez, and that there is no record of an Amber Gonzalez in the voter record at this address.
Mr. Gessler? Mr. Gessler?
Certainly. So same arguments, rest on the same arguments we made before. I don't know if this is an instance of misreading of the database or an instance where the person registered in Westminster but put down an address that was also in Westminster. And again, if they're registered in Westminster and they're also eligible to vote in Westminster, they can properly sign it. And then lastly, there's always the possibility, and again, I don't know because I don't have the voter registration record in front of me, but there of course remains a possibility that Amber is a variant or a person's middle name, and that she signs it that way, which is not unusual.
I'm actually looking at the line by line determination by the clerk, and it's not the first name, it's the last name that seems to be the issue here. So, but we'll be taking a look at that at the finding.
Thank you, Your Honor.
Okay, thank you.
Mm-hmm.
We would move to objections 63, 64, and 65. I believe this is a group objection that we have to dates once again. And these are in section 69 on lines 13, 14, and 15. and if you look at our page 42, you'll see the dates go from September 16th, and then they go back in time to September 14th, and then you have another date for September 14th, but then you jump ahead to October 14th. So we believe that this is invalid information that would need a cure, Your Honor.
Need a cure, which of course you don't believe it can be done.
Exactly, Your Honor.
Mr. Gessler?
Same arguments as before. The dates are properly within the range. The dates are proper. The fact that they're out of sequence is not an issue. There is not a requirement that they be in the same sequence throughout the entire petition, but only that the dates are proper. And again, people will have gaps that they go back and fill in with signatures by presenting them to voters, and those voters put them in. So that's why oftentimes the date is out of sequence.
Your Honor, we will be dropping objection number 66, which is from section 69, line 22, Mr. Yarbrough.
And
we are also dropping objection number 67, which is from section 78, line 11, Casey Nugent.
all right, and then moving on to objection 68.
Objection number 68 is at the bottom of our page 42. This is from section 78, line 17. We believe that this is an invalid signature because the person cannot be identified and their voter registration cannot be confirmed under this name. What we read that name as is not in the voter registration. This person cannot be confirmed as a registered voter on the date that he or she signed the petition.
Could you tell me how you're reading the name?
Our best guess is Luzviminda, and last name I think might be Fajardo with a G.
Okay. Okay. Thank you.
You're welcome.
Mr. Gessler?
Without belaboring the point, same arguments that we've made before.
Okay. All right.
We would move to our final protest challenge, which is objection number 69. This is from section 78, line 21. We believe that this is an invalid signature because the voter registration cannot be confirmed. The person who signed at that address is not found in the voter record file. The address does not match. So the person's voter registration cannot be confirmed.
And what were you looking at when you could not, when you could not confirm this particular?
Okay, let me take a look at my notes here.
Sure. Right ahead.
This is like, we did have one like this, which is slightly different than the others. So this one, I think the address is in this voter's file, so that's an indicia of reliability. But I think when she signed with the wrong address. So it's that category. I think there was one like this where there's some indicia of reliability, and we'll grant that to this person. So it's slightly different than the others where you just can't confirm that the person at that address is in the voter file.
And you make that, you come to that conclusion because of the name?
No, the address history, the move history at the bottom of page 44 shows the addresses. If we read this correctly, which I think we are, she was at Newton Street, I believe.
On July 21st of this year. I'm sorry, January 21st of this year.
Yeah, I think that's correct.
And
I think she was at Wilson Court up until March 6th. And then she was, and then I think she moved to 7405 Newton Street in Westminster.
on January 20th,
Right.
signed on October 24th of 2020 with the Wilson Court address.
Yeah, that's correct. I'll grant that this one's a confusing one, Your Honor.
Mr. Gessler.
Certainly, the way I read the voter profile report below is that under the effective date on March 6th, 2020, she listed in the voter registration her residence address as 7390 Wilson Court, which comports with the address that she signed at. And then on January 21st, 2020, she listed a new address, which was 7405 Newton Street in Westminster. And again, this is why I'm a little uncertain about some of this stuff, because I am assuming, or at least what I infer from reading this profile report, that as of 5/13/2021, when it was pulled, that it listed 7390 Wilson Court, Westminster, as the residential address for the person, which meant, maybe the person moved back after January 1st, she moved back to 7390 Wilson Court. I don't know. But it certainly seems that based on her current address and the address, effective March 6, 2020, she was at 7390 Wilson Court, which is the same address that she signed at. So it seems appropriate on the face of this.
Ms. Parker.
Yes.
Just out of curiosity, are you familiar with these voter profile reports?
Not these in particular. No, Ms. Goldman.
Okay. That was all I wanted to know. Thank you. All right. So, Mr. De Herrera, that is it for the line by line?
Yes, Your Honor.
Okay. Before we move on, do you have any final overall general comments you would like to make?
No, Your Honor. I'd be happy to address any questions that you have. I thought we had a robust discussion as we went along, so I don't feel the need to do that. But I'm happy to answer any questions that you might have.
Well, I have none. Mr. Gessler, do you have any final comments on this section you would like to make?
I think Mr. De Herrera's characterization of a robust discussion is correct. I think I've made my arguments and prepared to move on to his next objection.
All right. So now the last piece that we want to talk about has to do with petition section number 33, which the protesters are alleging should be disqualified in its entirety because of irregularities in the, I believe you said petition section and line numbers. So, Mr. Rivera, go ahead.
Thank you, Your Honor. And let me pause to make sure that you have it in front of you.
I have a copy.
Nice. And at a big picture level, I think the circulator and their affidavit has put the clerk and Your Honor in a difficult position of trying to figure out what happened with this petition. For several pages, the petition looks like it should look. The numbers follow the sequence as they should. But then you get to a certain point, and I believe it's on page 54 of our document, where you have a new petition that starts. And then it goes back to the other sequence, and then it goes ahead to another starting of a petition. I believe there are at least 3 pages that are numbered 1 through 6. And so you have a lot of uncertainty and unreliability with this petition. And when I say that the circulator has put the clerk and you, Your Honor, in a difficult position, is that the circulators, I believe, were trained that these forms matter, the process matters, the requirements matter, and the circulator's affidavit matters. So this circulator provided an affidavit and should have given some clarity as to why this happened. Why are these pages out of order? And the circulator should have explained that despite these pages being out of order, these were all pages that I reviewed, so that it could remove that uncertainty that we have on this document on its face. Because the circulator did not do that, I believe there's a serious question as to whether or not this same circulator oversaw all those petition signatures as is required by the statute. So that is our difficulty, our objection to this section. Without some sort of additional information to render these petition signature pages reliable, we believe that they must be ruled invalid until that time.
Mr. Gessler.
Certainly. So the numbering is not sequential. I'd submit, actually, if you look at the every single petition, there's not a single petition where the numbering is actually perfectly sequential. Approved, had some issues with the numbers, as had every single, and consequently every single one that was circulated. So the actual line numbers are not dispositive as to whether something is valid or not. What matters is the circulator's behavior, their affidavit, and the content within the lines themselves. And that's what the clerk properly looked at. First and foremost, there is a presumption that this is properly accepted because the clerk and her staff did review these. They reviewed the circulator affidavit, and in fact, this isn't just a cursory review. This particular petition section was initially rejected. Then obviously we had the court case and with respect to the cover page and whatnot, and then it was ultimately accepted. So that was not a cursory review. It was in fact a careful review. But with respect to the concerns that the circulator, that how do we know that this was actually circulated by the circulator? You actually have a circulator's affidavit that he filled out, that he said each signature was made in his presence and it was a person that it purported to be and the best of his belief and knowledge and so on. And he signed that. And then as part of an additional submission, he signed that this was actually the format, this was Mr. East did, that this was actually what he circulated, and that while he was circulating it, he didn't insert extra pages, even though the pages may have been mixed up. Or at least the format, the petition section that he received, they were mixed up. But we have not one, but two affidavits from the circulator affirming that he properly circulated these and collected the signatures. And then, of course, on top of that, you have the signature lines themselves, each one of which has been inspected by the clerk and recorder. I'm sorry, by the clerk and her staff. And then finally, I think that ultimately the protest has to identify a specific statutory provision that this violated when he's, the concerns about these numbers being out of sequence for some of the pages. And I don't think there is a statutory violation in any way whatsoever.
Ms. Parker. So I'm hoping you could shed some light here. Petition section 33 was one of the initially disqualified petitions for reasons other than what we're talking about today.
That's correct.
Okay, and then on the 21st, the court, or prior to that, the court said that you needed to go back and check the signatures on the petitions that had been previously disqualified, and this was one of them. Is that correct?
That is correct.
Okay, so when you looked at this petition, and clearly I can see that the numbers are out of sort of sequence, and it seems to be that a couple of pages have the same line numbers and that kind of thing. When you looked at it from a signature perspective, what did you find?
Right. In regards to the pages out of order and the line numbers, I do want to comment, and this seems an appropriate time to do so, that line numbers, even throughout this hearing that have been cited, for anyone who's trying to follow along with, for example, the certification that has been released, or any number of the amendeds or the initials, all the output that we cite, we had internally a petitioner's number, and then we had a city clerk's office line number. We had to, in order to process these, we had to renumber lines. As has been referenced prior, the actual petition that was approved as to form had 2 lines 59, and then jumped from line 65 to 75. That's every single petition. So internally, any line in our signature verification database beyond 59 is not going to match what you see in some of these exhibits. So I do want to make that clear. As such, having these pages out of order or different line numbers was not something that we considered to be a violation. We were systematically and methodically having to renumber every signature line that we were verifying.
So what you're saying is that that when you both initially looked at the petitions and then you subsequently looked at the disqualified petitions, the line number out of order did not affect your decision as to whether it was a valid or invalid signature. Is that, do I understand that correctly?
You're absolutely correct. And I do recall this particular petition very clearly, because we had to do quite a bit of renumbering for this particular section. But that was not considered any kind of reason to kick it out.
Okay. And it was, and I don't know if you have it in front of you, or to the best of your knowledge, were all the signatures obtained prior to the signing of the affidavit of circulator?
If you'll indulge me, I can take a quick look.
Okay.
It appears so. The affidavit was signed by the circulator on the 13th of October.
On average, how many signature lines appeared on each petition section? You referenced anything above 59, but how many would you say?
I honestly couldn't give you an average. I mean, we processed line by line over 27,000 signatures. Each petition section was different. Many of them were filled, and they show that you could fill to, I forget what number, 104, I believe, that they end with, but the maximum number of signatures you could actually put in a petition section was 96, I believe. Some of them were completely full. I can remember one in particular where there was 1 signature. So it varied. It varied. I would hesitate to attempt to put a number on it because it would most likely be incorrect.
And the listing of line number 59 twice, was that something that got missed upon the approval, or when did you recognize that or see that?
I believe it was missed upon approval, but I will also note that we were not approving it as to proof every individual line. We were assessing that as to form to make sure it contained all the legally required elements as stated in our charter, our code, and the Colorado Revised Statutes, which is silent on numbering, if I'm correct. So we did notice that October 30th or 31st, when we were actually processing, scanning, and beginning our signature verification process, the first step. So we did notice it back in October and made sure to train our staff who were verifying to in turn begin to make note that beyond signature line number 59, the signatures would not match the page. And that was the only way we could do it.
Okay. Do either Mr. De Herrera or Mr. Gessler have any questions for the city clerk?
No questions, Your Honor.
No, Ms. Goldman, no.
Okay. Any other
Thank you.
comment? Oh, yes.
I do have some final comments on this. I do think that this is a valid and important protest. The details matter, the numbers matter, and there might be slight variances in many petitions. I don't think that fact can excuse the significant discrepancy and the significant questions that are raised by this particular section. And I think that it's possible that those questions could have been addressed already in the circulator's affidavit, but for whatever reason they didn't, and that raises the flag for me. It looks to me like the circulator signed a form affidavit without regard to the substance of this section, and that is also, it's a flag. And so I think it's an important question. I think it's a serious question. I don't think details and significant discrepancies like this should be overlooked. I think there are a lot of charges we hear in today's society about voter fraud and problems with things, and it's discrepancies like this that can lead to that. And so there is a process by the statute where the petition committee could have resolved this issue through a withdrawal and a potential cure, but they didn't. So we think it's a valid and important protest.
Mr. Gessler.
Ms. Goldman, are you asking for final argument or a response to Mr. De Herrera?
We're still on this item on the petition section number 33.
I have no further comments on that.
All right. Okay. All right. Well, seeing none, then I think unless there are some loose ends to tie up, I'm ready to hear your final remarks. And let's see, I'm trying to remember. So, Mr. Gessler, I'm going to let you go first, and then I'll conclude with Mr. De Herrera, who gets the last word.
Ms. Goldman, may I suggest that normally, as the proponent of the protest, Mr. De Herrera goes first, I go second, and then he has an opportunity to reply.
Okay.
Your Honor, I'm flexible. I didn't prepare remarks to conclude. I think that we made our points, and we believe that the documents speak for themselves on a significant number of these challenges. We went through them, line by line, and so we rest on the arguments that we made on each one. And I've opened myself up to questions if you have any. If you would like any additional briefing on any of the issues, either factually or legally, we'd be happy to provide that. But we rest on the arguments that we've made as we've gone through.
Okay, thank you so much. Mr. Gessler.
Thank you. With respect to this protest, I think the protester has three hurdles they have to overcome. The first hurdle has to do with interpretation of the law or ambiguities or uncertainties in the law. So, for example, the power of attorney discussion we had. Let us assume, for sake of argument, that argument could go either way. The tie in these instances go to the voter, go to allowing and enfranchising people. to be able to have their signatures counted. So when you have these legal issues or legal gaps, unless there is a clear prohibition on something, the signature stands, unless there's something that specifically says that is incorrect or that that signature cannot stand for this reason, and this reason has to be tied to a very specific statutory or regulatory provision. So I think that's the first hurdle, is the legal arguments. Unless it's very clear, the signatures stand. The second hurdle they need to overcome, which I don't believe they've overcome in their instance, is the first hurdle. I don't think they've overcome the second hurdle. And the second hurdle is what I would call, instead of the legal interpretation, the evidentiary interpretation, interpreting the evidence before you. So for example, there are arguments that the signature was illegible or that a date was illegible. Well, the evidentiary interpretation, so there's a dispute about that. Again, in this instance, the evidence is that they were submitted, they were legible. And the reason why that is the case, that's the presumption, is because the clerk made that determination. What the protester has to do in this instance is provide strong evidence, actual evidence, that that evidentiary interpretation was wrong. So it's not a matter of one person saying, well, this is illegible, versus the clerk saying it was legible. That's not the contest. The presumption is that, and I'm using this as the example, the presumption is that the signature is legible, and there has to be very strong evidence, not an interpretation or an argument, but actual evidence that that signature is illegible or that the signature was wrong. And that evidence would look like, for example, an affidavit from the voter saying, no, I never signed this. That's crazy. Or an affidavit from, or testimony from a witness saying, I was standing there and that person came up and said they didn't want to sign, but somehow their signature appeared. That's the type of evidence that's needed to overcome these presumptions, because the clerk has already accepted all of these signatures. So it's not one interpretation versus another, either legally or evidentiary. You have to have strong, compelling evidence to overcome that. The third hurdle they have to overcome is, and I know Ms. Goldman, you're familiar with this, is, of course, the substantial compliance test. And what the substantial compliance test basically says is that people will make mistakes. Mistakes happen. You have thousands of people signing in good faith, trying to get their signatures on, and sometimes they make mistakes. So for example, someone making a mistake that they're in Adams County, thinking when in fact they're in Jefferson County because the street zigged or zagged, or they were one block off, or they weren't sure which county they were in. Let us assume, for argument's sake, that that's a mistake. What the substantial compliance standard says is you still count that, because you look at the extent of noncompliance, the purposes for noncompliance, or the reasons for noncompliance, whether there was a specific intent to mislead the electorate. And the third element is, were the purposes of the statute achieved? And the purposes here are, can we identify that voter, connect that voter as someone who is registered and eligible to vote to be able to sign this petition? And in all of these instances, the clerk was able to make that connection. So the purposes of the statute were achieved. Now I'm working backwards on the three-pronged substantial compliance test. There's no evidence whatsoever of an intent to mislead the electorate. And to the extent there's any errors, they're all very minor errors, ones that occur here and there. So for example, I would, at Adams County versus Jefferson County, that's a minor error, because we know the city is Westminster, we know the address, we know that voter's name matches that address. So I'd submit that overall, that there's three hurdles that the protester has to overcome. The legal interpretation, the tie goes to the voter. The evidentiary hurdle they have to overcome. In other words, there is a presumption of regularity. There's a presumption that these are correct. Because the clerk reviewed it, they have to show evidence to overcome that presumption. It's not a 50-50 flip a coin. It's strong evidence to overcome that. And then finally, even when there is an error, the substantial compliance test, they need to show that there was a widespread error, not a minor one or a major error, They have to show there was an intent to mislead, and they have to show that the purpose was not achieved under the statute. So I'd submit that collectively those three hurdles have not been overcome on any of these signatures.
Your Honor, if I could rebut for just a second, and I won't go through all the arguments that we've gone through because I think I've tried to make my point, and hopefully that did come across. But as to the substantial compliance standard, that can come into play in certain circumstances, certainly. But there are many circumstances that we went through line by line where there is no substantial compliance. The person is either was registered the day that they signed the petition, or they were not registered. The person can be verified as being a registered elector as is required, or they cannot be. And so there are many of the situations that we went through today where, regardless of a substantial compliance standard, that won't apply to the particular situation of whether or not a signature is invalid. And as to the standard is that this petition has to meet the statutory requirements in order to proceed to a recall. The law is very clear on that, and there's a process by which we get to protest, and then under certain circumstances, so long as they have not already done it, the petition committee can cure information that could be curable. So there is a process. That's what we're doing here. I don't want to belabor all of the issues that we went through, but there are many, as you know, I think that we discussed where the substantial compliance standard can't save a person who was not registered when they signed the petition, or cannot change the fact that the person without further information can be confirmed as a registered elector. So with that, I would conclude.
All right.
Ms. Goldman, may I make one last statement? And this is not directly in response to Mr. Herrera, but I just want to make sure that we all formally understand that we do that the recall committee does object to the inability to include the affidavits and the evidence that we provided. Our argument is that this hearing is to look at the petition in its entirety to determine whether or not it met the statutory requirements, as opposed to specific signatures of the petition. And therefore, it is proper for us to be able to bring in evidence to rehabilitate specific signatures. I understand you've already made a decision, but I do want to make sure we formally lodge our protest on this.
I've duly noted. All right. Okay, so next steps. State statute gives me 5 days, 5 calendar days from the day of this hearing, write and submit my findings. So the last day to do this will be next Tuesday. I will be submitting my findings to the city clerk, to Ms. Parker, and with instructions that she provide that information to the affected parties. That would be Councilmember Voles and the legal counsel representing both the protesters and the petitioners. And so I would strongly urge you, and I know you will, pass these on to the people that you represent. Seeing nothing else, I want to thank you for your participation today. I think this was, these are never easy, but I think this one, as they go, was relatively so. So it is now 12:49 p.m. and this hearing is concluded. Thank you very much.
Thank you, Your Honor. It was a pleasure appearing in front of you.
Thank you very much.
Thank you for your work, Your Honor.